Good afternoon, Sir Jeremy.
Thank you.
This hearing is in the matter of case number CFI-009-2023 and is being held by way of video conference before Justice Sir Jeremy Cooke, who is appearing with us from the UK. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Holman, Fenwick, Quillen, Middle East LLP. Lead counsel is Mr. Sharif Shivaji KC. The defendants are represented by Joan Stay. And we have with us Ms. Heather Martin. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
Confirmed, thank you.
Confirmed, thank you.
Thank you.
Confirmed.
Right. Well, question is in what order we deal with things today. I've read the papers. So the first question, I think, which is simplest to get out the way, the extension of time point.
Sorry?
70s, what is it?
Yeah, no, it started, I think in 80 or 78, 80, I don't know. Or 30. Sorry.
I'm not sure what's going on, but the various people who ought to have their microphones off. Thank you. So unless you're actually going to be speaking, please have your microphones off. It seemed to me the place to start was probably with the extension of time and the relief from sanctions point, which seem to me to be matters that can be dealt with very briefly indeed, as I've read the papers. So I'm simply going to ask the parties whether they actually have anything additional that they need to say on top of what appears in their skeleton arguments.
My Lord, just on the claimant side, perhaps I could just make a few observations, if I may. Firstly, on the relief from sanction point, we say this is a very minor point, and if it weren't really for the jurisdiction dispute, I'm not sure that we would be making much of this, if at all. Our view is that the jurisdiction challenges are unwarranted as a matter of substance, and we say the relief from sanction is another nail in the coffin. But I don't for a moment say that it should be determinative of the outcome of this hearing. And that's why, in fact, we put it to the end of the agenda, because it seemed to us that if you're with us on jurisdiction, that might be a further reason to refuse the fifth defendant's application. But well, I'm not. Yes. I'm not suggesting. So I'm so sorry to interrupt.
No, I interrupted you. Let you finish your sentence at least.
But I'm not. I mean, I for the claimants, I act for in particular the second claimant, who's an officer of this court, bringing proceedings on behalf of the estate supervised by this court. If the court thinks that we are wrong as a matter of substance on jurisdiction and that the proceedings are in the wrong court, as an office holder, we would of course abide by that. And I wouldn't be trying to persuade your lordship that due to some technical delay on making the application on time, that should somehow reverse the result. So that's the reason why I say it's a minor issue, but examining the reasons for the grant of relief from sanction, we do say on the merits they don't hit the Denton test, and that is a reason for your lordship to refuse permission. I mean, what I had in mind, in fact, was to put this to the end of the agenda, because we thought today is really about getting on with jurisdiction and getting into the weeds on that. And that really is where the time should go today. And then we suggested revisiting the relief from sanction point right at the end and really only spending a few minutes on it, because your lordship will have your own view as to whether or not relief should be granted. It's ultimately in your gift. It's not a matter of inter partes submissions. So that's all I had to say on relief from sanction. And then on the extension of time, it's as regards the fourth defendant, we do say that it is straightforward and that we should have the extension, and we're only talking about an extension of 8 days. As regards the first to third defendant, they are, as we understand it, not appearing today. but Miss Martin can inform me if I'm wrong about that. There has been a material development in that yesterday they entered an appearance in these proceedings and are now being represented by Jones Day. We are pretty surprised about that because we have asked repeatedly for them to engage in these proceedings. And we have also asked Jones Day repeatedly to confirm whether or not they're receiving instructions from the 1st to 3rd. And the answer that we've had hitherto is that they weren't receiving instructions. And there did appear to be some degree of coordination between the defendants. And when your lordship had to look at the stay application, in your lordship's judgment, you noticed that there was at least some degree of coordination because all of the defendants are represented by the same law firm in Switzerland, and previously they were all represented by Clifford Chance in this jurisdiction before Clifford Chance were disinstructed. So we were a bit surprised to see their arrival. Their arrival also heralded an acknowledgement of service which says they'll be challenging jurisdiction on the grounds of the expiry of the claim form. And because they've actually isolated that point and they've now entered an appearance, we don't think it would be appropriate for the hearing against them to go forward on an ex parte basis today. We think it would be a better use of the court's time for that to happen on an inter partes basis. Now, if Ms. Martin says that it can happen on an inter partes basis today, then that's brilliant and we'll be happy to crack on. But if she says that they're not prepared to deal with it today, then with some substantial regret, we think that has to be put off, although we would not want it put off for very long. And I say the reason I say it should be put off is because firstly, Jones Day's position hitherto has been that application should be heard on an inter partes basis with the 1st to 3rd participating. But secondly, we say that if we've got to go through it on an ex parte basis, I'm going to need time to develop those points. Your lordship will want to look at it quite carefully. And it seems inevitable that there will then be a later complaint from the 1st to 3rd defendant that we've missed something or got something wrong. And then we will be back before your lordship re-arguing exactly the same points in a few weeks' time. So for our part, we would ask that that's put off, but put off for a very short period to come back for an inter partes hearing, and we will make ourselves available if your lordship's prepared to hear it at your lordship's convenience to have a hearing maybe for an hour to dispose of that.
I think your approach to the relief from sanctions point is realistic. If the court thinks that justice requires that the matter go elsewhere and not be dealt with in the DIFC, then it would grant relief from sanctions. I'm bound to say that, you know, the period of time, of course, is minimal in terms of delay. The application for relief from sanctions should have been brought at once and is delayed, and that in itself is a very strong factor. But as I say, if justice required the matter to go ahead anyway, I would give relief from sanctions. So it seems to me, subject to anything Ms. Martin may say, is that I should deal with the substantive arguments on the stay or dismissal that's being sought by her on a de bene esse basis, and with the indication I've already given as to what the outcome is likely to be in relation to relief from sanctions. So far as extension of time is concerned for the claimants, I just want to hear very briefly from Ms. Martin as to whether she's got anything additional to say that above and beyond what appears in the skeleton argument. Obviously, I've read all the papers and I've plainly come to a provisional view about it.
Thank you, Your Honor. First, I wanted to address the point about their surprise at our appearance on behalf of the individual defendants.
Well,
and
I don't think there's any point in going through that, Ms. Martin. I know the history. I can see what's happened. I'm not in the slightest bit surprised. It's exactly what I would have expected from the past history. Whether inferences fall to be drawn from that one way or the other, well, that's a matter for argument at the end of the day.
Well, certainly, we can also put in evidence on that, Your Honor. But in any event, we would say that the claimants have approached their application as if it's a foregone conclusion that an extension of time is merited under these circumstances, and that is simply not a position that's consistent with the case law. Now, as to whether or not the hearing should be heard on an inter partes basis as to the first through third defendants, we would say that the answer is yes, and it is our intention to submit evidence on their behalf as quickly as possible. We are hoping even today, but if we receive alternate directions from the court, we are happy to abide by them. I would assume that claimants counsel would want some time with that evidence, would want the ability to respond to it, and that we should proceed accordingly, either with the rules or in accordance with directions from the court on the timing.
Right. Well, so far as the first to third defendants are concerned, if that's the position that's being adopted, I shan't deal with that today. I will deal with the position so far as the extension of time for the fourth defendant is concerned. It seems to me absolutely appropriate there should be an extension of time for all the reasons that have been given in the skeleton argument. This is a case where justice requires it to be done. So I extend time for the service against the fourth defendant. Very good. We can then get on with the substance of the matter. It's your application, Ms. Martin, in relation to seeking dismissal or stay of the proceedings against the fourth and fifth defendants. So the floor is yours.
Thank you very much, Your Honor. First, we would like to start with, and may I ask the court, would you like to hear all of our grounds at once, or should we proceed one by one? First service, then lis pendens, and then forum non-conveniens?
Whichever way you want to deal with it. I should have thought one go was probably the most sensible approach, but
Right. We'll begin addressing this issue of service on the fourth defendant in Singapore. Service serves a number of fundamental purposes. One is notice, and that is not an issue here. The second is the establishment of jurisdiction as recognized by Barton versus Wright-Hassel. I'm referring now to the bundle at N22, page 3270, paragraph 8F. As a general rule, service of originating process is an act by which the defendant is subject to the court's jurisdiction. The claimant's Singaporean service attempt fails to establish jurisdiction under Singaporean law. For this reason, the claimant's service attempt on the fourth defendant in Singapore should be set aside. The RDC rules...
Sorry, let me stop you there. You said it is not valid service under Singapore law. I haven't seen any evidence of that anywhere.
It does not establish jurisdiction over the fourth defendant under Singaporean law.
What does that mean? You mean Singapore court doesn't have jurisdiction?
No, it means that the Singapore Supreme Court would not recognize the DIFC court as having jurisdiction if the claimants were to prevail and then go to enforce an award in Singapore.
What's that got to do with the price of eggs?
Well, because service serves multiple purposes, not just notice, but also jurisdiction. And this
Now, Miss Martin, let's get down to brass tacks here. There's only one question that matters in relation to the validity of service, which is it valid service under the law of the DIFC? And that depends on whether or not service is effected in accordance with the procedure in Singapore for service. There is no issue, as I understand it at all, that service was valid under the law of Singapore. Am I right or am I wrong?
We disagree with that, Your Honor. And what I would ask the court to do is look beyond simply the Singapore's Rules of Court 2021, Order 7, Rule 3, the proposition that the claimant cite that ordinary service of a document may be affected by leaving the document at or posting it to, in the case of an entity, its registered or principal address. First, we would say that that's not what happened here in any event, that the service, the principal or registered address noted on the claim form was not where the document was served. But even looking beyond that, what I would ask the court to do is look to its own guidance as to the enforceability of DIFC awards in Singapore and the agreement that it has come to with Singapore. And this is at paragraphs 10A through D. And therein it states that DIFC courts must have had jurisdiction according to the conflict of laws rules determined to be applicable in the by the Supreme Court of Singapore to determine the subject matter of the dispute. The Supreme Court of Singapore will generally consider the court to have had require jurisdiction only where the person against whom the judgment was given meets one of the following 4 criteria. And so taking those one at a time.
But
A,
why is this relevant?
because the Singapore
Whether or not it's enforceable in Singapore is nothing to the point.
it would be
So far as this court is concerned, or establishment of its jurisdiction, it is interested in only 2 things. One is whether there's been service that's valid in accordance with DIFC law, and that depends in this case upon whether the service is in the form that's acceptable in Singapore. And there is no issue about that and no evidence before me from any Singapore lawyer to suggest that it is in any way wrong. And as a matter of Singapore law and the rules of court in Singapore, it's valid. Miss Martin, this is completely hopeless from your perspective. I just can't understand why you're trying to argue that because there's a problem of enforcement, it affects validity of service. It doesn't.
It is simply our
position. Is there any answer to that?
It is our position, Your Honor, that when looking at this court's own rules, that it should look beyond the bare service requirements and that it should look to jurisdictional issues because that is one of the purposes of service.
Well, I'm against you on that. I've read all your arguments. And unless there's something additional you wish to say on it, it just seems to me to be an ill-founded argument and a waste of the court's time to hear any further points in relation to it. Of course, if you've got things you need to say about it, then don't let me stop you. But I just don't see this at all as being relevant to the questions I have to decide.
I do believe we've been able to say what we need to about it. Thank you, Your Honor.
Thank you very much. All right, next point.
Yes, Your Honor. If we may next turn to the Liz Pendens point.
Yes.
It is, of course, our position that the court should decline to exercise jurisdiction due to the Liz Pendens of the Swiss proceedings. The Swiss proceedings predate the DIFC proceedings by 2 weeks. They mirror the issues raised and the relief sought in Switzerland, and they did not come as a belated surprise to claimants who learned about them the day after they were filed. And through the process of the correspondence between the parties, had plenty of indication that the defendants considered Switzerland to be the more appropriate forum. Now, this scenario invokes the principle of Liz Pendens, which is a statutory right in Switzerland that is grounded in international comity, and which allows the court to defer judgment if a similar court is active in another jurisdiction. So I turn to claimants' arguments on the point because I don't intend to rehash our skeleton. The claimants contest Liz Pendens as a standalone basis on which the court may decline jurisdiction, and do so on the basis that the principal English court case cited by the 4th and 5th defendant tackles the issue as regards pre-Brexit EU authorities, namely the Brussels I recast, that effectively made England and Wales parties to the Lugano Convention. Now, we posit that this criticism is short-sighted for 4 reasons. First, English courts have been willing to use Lugano Convention criteria reflexively, as they say, or by analogy, in relation to parties in non-member states. One such case is Ferrexpo versus Gilson Investments Limited. The citation to it is 2012 EWHC 721. And my apologies, it didn't make it into the bundle. It was we found it belatedly, but we are happy to send it to the court if it would assist it. And it noted therein at page 126 that there is wide academic support for the view that some reflexive approach should be adopted. Second, the UAE has never been a member state of the Lugano Convention, and yet the DIFC court has already acknowledged the potential applicability of the Lehman Brothers case, distinguishing it only on the basis that the prior pending proceedings, which to be clear were not Swiss conciliation proceedings, were part of a contractual dispute mechanism and not a judicial proceeding, in the way that Swiss conciliation proceedings have been found to be by the English High Court. So here I refer to the Albufeira National Insurance Company versus Horizon case, which I'll refer to as the Horizon case, and that is the bundle N16, page 3188. Thirdly, as a practical matter, layman is useful in assisting the court with determining specifically what a Swiss conciliation proceeding is and whether the court should afford it the status of a judicial proceeding or instead treat it as a consensual non-judicial mediation, as this court did regarding the mechanism in the Horizon case. It bears the court's consideration that after extensive analysis, the High Court found Swiss conciliation proceedings to be the former. They found them to be judicial in nature and mandatory. Now, lastly, the claimants themselves cite authorities from the pre-Brexit era whose holding was informed by the recast Brussels I regulation, namely the Lungow case, and they therefore cannot credibly claim that such authority is of no use to this court. So while informative as to approach, Lehman Brothers is also factually distinguishable on its procedural posture. There, the Swiss conciliation proceedings had been declined jurisdiction by the Swiss court, and the Swiss appeal dismissed, causing the High Court to assert jurisdiction over the matter, a decline to order a stay. Now, unlike the scenario in Lehman Brothers, the Swiss proceedings here remain active, making a strong case for the DIFC court to decline jurisdiction. The claimant suggests that recognizing lis pendens here would somehow be inequitable because of claimed surprise on the liquidator's part at learning of the pendency of the Swiss proceedings. On this point of surprise, it bears mention that claimants have changed their story several times. First, in their evidence in relation to the fifth defendant stay application, claimants stated, "I have no information as to the precise nature of the Swiss proceedings or when they were commenced." This statement is patently false, given the claimant's knowledge of those proceedings on the 20th of January, 5 months earlier. They continued their theme of false ignorance in their argument at the skeleton, where they state at paragraph 5.3a and paragraph 15, it appears that the defendants secretly commenced their own proceedings in Switzerland against the claimants in order to create a jurisdictional conflict with the DIFC proceedings. Jones Day challenged the claimants about the veracity of the statement, following which numerous rounds of correspondence were exchanged. On the back of this correspondence, claimants agreed as a matter of common ground that they learned about the Swiss proceedings on the 20th of January 23, but maintained their claims of surprise at the time because supposedly the Swiss proceedings were not the subject of pre-action correspondence. Now, this statement is also false. During the negotiation of the standstill agreement, the parties explicitly negotiated whether prohibitions on filing would be unilateral, only covering the claimants, or bilateral, also covering the intended defendants. The parties agreed on language making the restrictions unilateral as to the claimants. These negotiations are detailed in the pre-action correspondence and described in detail in Mr. Devenish's fifth witness statement, bundle reference being E12, page 461. Paragraph 17. On this basis alone, any surprise by the claimants is due solely to their own lack of forethought. Now, we have not been able to obtain the claimants' agreement as to the date on which they first learned from Clifford Chance that the intended defendants considered Switzerland to be clearly the more appropriate forum. But in any event, if the court is curious about that fact, I invite it to put a direct question to claimants' counsel. Following these developments, claimants should have recognized that the intended defendants would assert their rights. The most that claimants can say about the defendant's conduct in the Swiss proceedings is that they were not the subject of a formal letter before action, but that is no matter here because letters before action are not a requirement to recognize lis pendens. And additionally, formal letters before action are neither required nor a typical feature of Swiss litigation in the way that they are in English and English style proceedings. In any event, these claims of unorthodox conduct are a diversion and should not distract from the relatively simple issue of lis pendens before the court. And with that, Your Honor, I would pass the time to claimants' counsel.
Are you not going to deal with foreign convenience now?
Oh, apologies. So when we had discussed this with claimants' counsel, they had suggested that we go one issue at a time. I'm happy to go through all of our grounds at once. That's fine.
I think that would be simplest, really. Thank you very much.
Sure, thank you. So as to forum non-conveniens, we proceed today on the basis that the court is well aware of the Sfiliata test, and the bulk of our affirmative case is set forth in our skeleton argument. Dicey Morris captures the essence of the issue before this court in section 1240, and that is the section that relates to multi-defendant cases. It states, Especially difficult considerations come into play where the claimant wishes to proceed in England against a number of defendants, where the court otherwise has jurisdiction over one of them, referred to as the anchor defendant, but where the subject matter of the action is otherwise more closely connected with a foreign country. The paradigm case in which the issue has arisen concerns a claim against the English parent of a group of companies, together with its relevant subsidiaries concerning an alleged tort in which the claimant's damage was suffered abroad. It goes on that evaluation of anchor defendant issues, quote, requires a consideration of the case as a whole, all the defendants, and not simply the claim against any one in particular. A very important factor in such cases is the avoidance of the risk of irreconcilable judgments. Now, we organize our discussion around these 2 points. First, looking at the defendants as a whole, the claimant's own portrayal of the issues makes the fourth defendant in Switzerland the organizing principle of the allegations. This portrayal is substantiated by the evidence of the individuals, which is yet to be filed today, showing that 2 of the 3 traveled to the DIFC for BSA board meetings less than a handful of times. Second, there's not only the possibility or likelihood, but the existence of multiple proceedings between the parties on the same issues. Although the claimants leave this factor until last in their submission, we believe it merits primary consideration by this court. So taking each of those 2 points in turn. The foundational narrative of the claimant's case is that the fourth defendant, acting as the first claimant's majority shareholder, orchestrated a dishonest scheme to wind down the first claimant's business, using the individual defendants in their roles as board members and the senior executive officer, respectively, as its tools. The fifth witness statement of Mr. Devonish, and soon to be in greater detail in the evidence of the individuals, will describe how the epicenter of these events was Switzerland. Mr. Sassoon attended one of the 3 total board meetings that he attended for BSA in the DIFC, and the other 2 were attended either in or from Geneva.
When you say in or from Geneva, what you mean is that he attended presumably remotely by Zoom or video or whatever the equivalent was, or phone.
I believe that one of them was actually in person in Geneva, but if I say from Geneva, I do mean telephonically.
Yes, so what I had understood by the evidence on that was that the meeting took place elsewhere, sometimes I think in the DIFC and sometimes elsewhere, but that different people, as is commonly the case, attended from their hometown, so to speak. Have I understood that right?
That's correct, Your Honor.
Okay. Can I interrupt you? There's a question I'd like you to deal with.
Sure.
In relation to the Spiliada, which is this. The Spiliada drew the distinction between service as of right and service as a matter of the court's discretion, which in the case of English law, of course, service as of right, you can serve on anybody within the jurisdiction as a matter of right without the court's leave, but you needed the court's leave to serve abroad. But the DIFC jurisdiction works entirely differently, because the DIFC jurisdiction is a statutory jurisdiction. And so services as of right under the statute, if the particular case or defendant or claimant comes within the judicial authority law. And so the question I would like you to deal with at some point is whether what is said about burden of proof in the context of cases where service is of right applies in the context of the DIFC and what it regards of service as of right. Do you understand my point?
I believe I do, Your Honor. And we debated this question because it wasn't clear to us from the DIFC law what the position was, if it already has one. And what I would say is that under English law, where service out requires an application to the court, claimants are required to make a showing, and they have to demonstrate to the court that there's good reason for service to be made where and when it is being made. Because there is no such requirement in the DIFC, it is the fourth and fifth defendant's position, Your Honor, that the court should more heavily scrutinize service by claimants because it has never been scrutinized in the first place.
Well, of course, it's a long-arm jurisdiction, not quite as long as some US states. But the question is quite how you apply the Spiliada test to what is a different jurisdictional setup. Anyway, there we are. It probably only goes to the point of burden of proof, which is unlikely, I think, to be decisive here.
Thank you, Your Honor. Hopefully I cover off the rest of your question in the rest of my argument, and if not, I will attempt to do so at the end. And I just wanted to quickly circle back to attendance at board meetings that even Mr. Astruc, who was a board member for a much more significant period of time, including up until the point of insolvency, that of the 15 board meetings he attended, only 3 were attended in the DIFC, with the other 12 either taking place in Geneva or him attending telephonically there.
I didn't understand any of the board meetings that actually taken place in Geneva. At least I don't have any evidence of that before me now. Is that right?
I may have misspoken. I know that there were some that took place in Zurich. I believe at some period of time after the wind-up vote, it wasn't particularly denoted where the meeting took place. People just attended telephonically after that time.
There were some board meetings that were simply telephonic altogether.
There were. I also think the court may be referencing some of the shareholders' general meetings.
No, I'm talking about board meetings only for the moment.
Okay. We have a schedule that is being filed today, and I don't have it before me, but I can obtain a copy if it would help the court today.
It may give rise to argument, of course, but as I understood the position, and you can tell me if I'm wrong, on the evidence that's currently before the court, board meetings should have taken place nominally in the DIFC because it's a DIFC company, BSA. And of course, people might well attend telephonically from all over the world. So that each board meeting ought to be headed DIFC in order to be effective, being regulated, the company being regulated and so on under DIFC law. And unless there is specific reference in the minutes to it being actually happening physically elsewhere, I think my assumption would be that the board meetings did take place in the DIFC with people joining from elsewhere. But is that not a fair assumption?
I'm not sure I know what the court is referencing when it says that there may be some sort of requirement or presumption. Having worked in-house at a private equity shop for 7 years, my experience is that the board generally traveled for meetings and that they rarely took place in jurisdiction. So if the court has an authority that it would like to point me to, I'd be happy to look at it.
It's simply that because you're a DIFC company, that's where the assumption would be, particularly if people were joining simply by telephone from all over the place, which they may very well be.
Well, certainly before the merger, all, I think, of the board meetings took place in Zurich that I saw. So I don't think that's a fair assumption as to BSA.
Okay.
And as I understand the narrative, after the merger, the new shareholders representatives wanted to obtain more visibility on the operations of BSA, and that is one of the reasons that they started moving some of the board meetings to DIFC at that point.
Okay.
Would the court like me to take it to some examples of the board meetings, or does it have the evidence before it and it's happy to go through it itself?
Well, you may want to give me some references if there are meetings of that kind.
Certainly. Well, one where attendance was from Geneva, even if the meeting was nominally held in the DIFC, can be found at bundle J9, page 1176, where the first defendant was over the telephone.
Yeah, I said I don't think a telephone attendance helps particularly.
Okay.
Because say you might be anywhere, might you? You might have been traveling abroad from your home. You might do it from home. You might do it from the office where you habitually work, obviously.
All right. Well, another example I was going to give was just such an example. I will note it simply for the record, recognizing that the court is not minded to pay a lot of attention to it, but that is at bundle J13, and the first page of which is 1199. And I would note on this one that where the first page says that it took place in the DIFC, if you turn just to the second page, it notes the place of attendance via telephone.
Yeah.
One more would be J11.
Yeah.
At page 1194. And again, this is not a board meeting. It is an extraordinary general meeting of BSA shareholders. This is one where claimants state that we misstate the place of attendance, but I wanted to bring it to the court's attention because we simply did not.
You say the attendance, the meeting was where?
From Geneva.
Geneva, thank you.
And we did actually ask the individual defendants to review their travel records to corroborate it with what the meetings of minutes said. That will be submitted in evidence today. Now, how we describe the alleged actions or omissions matters just as much as where the bodies were when they carried them out. The claimant describes the individual's attendance at shareholders' meetings as internal management of the company, and we would describe it as the exercise of intragroup corporate governance over the company. This court has on prior occasions been very careful to differentiate the internal management of the company and the real issues in dispute between the parties. And here I refer to the Protivity versus Mohammed Al-Majil case that can be found in the bundle at N72, page 4456 through 51. I'm sorry, paragraph 51. There, the court differentiated the internal management of the company as such from the accuracy of a report concerning the internal management of the company. Now, such a surgical approach is merited here, where we are talking about business governed by a business agreement, making it the first claimant's role to introduce clients to the fourth defendant, but the fourth defendant's role to offer such clients businesses and services at its sole discretion. The revenue from such clients to be calculated by the fourth defendant and then remitted in a retrocession. And the business agreement can be found in the bundle at J1, page 1055. We would ask the court to pay particular attention to that document. We think it's important. It is this intra-group company dynamic that is an issue, not internal matters such as taking on debt or paying out creditors in a preferential way or hiding assets or other accounting issues such as the usual issues in insolvency matters.
Why is this an intragroup matter? You know, we're not talking about a dispute under the shareholders' agreement. We're not talking about the winding up as such, but what we're talking about is the movement of assets out of the claimant company and the liquidator's complaint that all of that has been done in the face of a plan to avoid a debt to the Al-Kharalfi family.
First, Your Honor, I would say that we are not talking about the movement of assets. That's not what's pled. They plead the movement of business, which can be differentiated. It can be differentiated from the assets which stayed on the books, the assets that were there at the beginning.
The business of a company is part of its assets, all its contracts with its clients, all its contracts with its employees, its relationship managers. That's all part of its assets, isn't it?
This not as recorded on its balance sheet, Your Honor. The second thing I would say is that the acts that were allegedly omitted by the individual defendants were not within their corporate powers. So these intergroup dynamics matter very much to this case. They would have been acting ultra vires if they would. Pardon?
You know, so let's assume that both the shareholders here are involved in a scheme to wind the company down and to get rid of all its business so that the Al-Kharalfis don't get paid the 35 million that the DIFC court later awards them. Now, that's the essence of the case that's put under the Insolvency Acts of the DIFC. It doesn't make a scrap of difference whether both shareholders are agreed on doing that or not. It's not a shareholder dispute, is it? It's a dispute between the company and those who are responsible for depriving it of its business.
But if the
Isn't that right?
But if the people who are alleged to have omitted to do something that they were, according to the claimants, required to do, did not have the power to do that, there becomes a very substantial question of what their powers were and whether or not the court can make an order of a breach of duty for an omission to do something that would have been ultra vires.
But it doesn't matter whether it's ultra vires. If they do it, they do it. If the directors are involved in giving confidential information out and involved in a scheme whereby the assets of the company are dissipated, where's, you know, why does it matter whether they've got technically power to do it if that's what they've actually done?
Well, I believe we're creeping a bit into the merits here. I'm happy to get into it, Your Honor. The confidential information belonged to the fourth defendant, and that is clear from the employment agreement with BSA of the third defendant. And in addition, the assets of these clients were held at the fourth defendant. You simply can't have the activities of the first claimant without the activities of the fourth defendant.
Well, that's done. They're acting as the bank in question.
I'm sorry, Your Honor.
Well, I understand that, but I don't quite see how it impacts on the point.
Well, as we would say, we would just ask the court to take a very surgical look at how it characterizes what went on here, and not consider this simple movement of assets in the way that you see more simplified insolvency matters. It is our position that the claimant's portrayal of the DIFC as the principal jurisdiction is a classic example of the tail wagging the dog, and further reflects a clear case of the second claimant having failed to acquaint himself with the business of the first claimant and or the evidence. So going back to the second dicey factor recited at the beginning, the claimants dispute lis pendens as a decisive factor in the court's forum non-convenience analysis on 5 bases. So taking those one at a time. First, regarding lis pendens, the claimants state that the Swiss proceedings are embryonic. Now, in reality, those proceedings have been pending longer than these proceedings. Unlike here, where claimants were responsible for effecting service and drug their feet in doing so for several months, there in Switzerland, service lies entirely in the hands of the Swiss and UAE authorities, Switzerland being a civil law jurisdiction where it is the role of the court and not the parties to effect service. The fourth and fifth defendant understand that the documents were transmitted from Switzerland to the UAE on the 4th of July, 2023. And we considered it a twisted irony if the fourth and fifth defendant were denied the jurisdiction of a clearly more appropriate forum elsewhere, because the glacial pace of the UAE diplomatic channels apparatus has caused the court of the UAE to conclude that it is a superior jurisdiction to Switzerland for these claims. On the second base they cite regarding lis pendens, the claimants state that Swiss proceedings do not duplicate the DIFC proceedings because the claimants, quote, seek a host of remedies which are not currently covered by the conciliation proceedings. Now, to be clear, the claimants seek a variety of financial remedies, namely damages, compensation, and an accounting of profits, whereas the defendants seek a single declaration that no financial liability is due and dismissal of any other claim by the claimants. These prayers for relief are both comprehensive and integrative of any subvarietals. So in other words, this is a genus species situation wherein defendants plead the genus and claimants plead the species. This genus species differential does not make these two matters non-duplicative. On the claimant's third claim regarding lis pendens, the claimants only argue that the DIFC court can resolve, or that only the DIFC court, my apologies, can resolve all the claims and frame the argument from the perspective of 3 different styles of claims: breach of duty, contract, and office holder claims. This is a recast version of their separate argument that Swiss court is not, quote, available within the meaning of the law. and which also mentions tort claims. So we'll address both of those together. The law does not require that claimants have the ability in the alternate forum to plead their claims in exactly the style they prefer. Dicey Morris states in paragraph 1242, it introduces a new section titled "Procedural differences are insufficient for overcoming a prima facie case for a stay." Now, elsewhere in Dicey, the language we believe is a little bit sloppy. It states in the text of a different section, which is paragraph 1231, and that is page 3475 of the bundle. The requirement of an available foreign forum means that the foreign court must have jurisdiction, personal and subject matter, to determine the claimant's claim. It uses the term claim. But if you look at the case that it cites in substance, what it says is that the foreign court must have jurisdiction to resolve the fundamental dispute between the parties. The issue in that case being the terms of a global intellectual property license. There, the court found that the courts of China did not have the ability to do so. We don't believe that that is the case here. These claims and issues can be resolved by the Swiss court. And I don't believe that there's any claim, even by the claimants, that the Swiss court cannot resolve the issues in relation to a Swiss bank and its subsidiaries, resulting in vicarious liability of the bank, particularly when the omissions alleged took place in Geneva. But if we take a step back, what the claimants...
I'm so sorry to interrupt, my lord, but can I just, for my note, I didn't catch the authority that my learned friend was referring to. She said that it was footnoted in Dicey, but I didn't get the name, and it would just be helpful for my submissions.
Certainly, it is Unwired Planet International, and my apologies for not providing that, versus Huawei.
The point you make is simply that as long as the substance of the claim is cognizable in whichever jurisdiction, the point doesn't assist. That's really what you're saying.
That's correct.
And I think, that would be generally recognized. But if there was a claim that was only capable of being made in one jurisdiction or another, that might be a reason to prefer one jurisdiction to another, mightn't it?
I don't see an authority that says that the claims need to map one-to-one. And I think that if were...
I understand that. It's you look at the substance of the thing, obviously.
Correct.
I mean, in this case, if the claims are being brought in relation to insolvency law in the DIFC, there would be a need, as I understand it, for the liquidation to be recognized in Switzerland, and then for the Swiss court to proceed on the basis of its own insolvency legislation. Have I understood that right?
That is what I understand as well. And I believe that that is consistent with all both parties' experts.
Yeah.
But I do want to address the claims one by one, because I do think that I think that they merit consideration, just because the Claimants Council has spent a lot of time on them. So addressing the sub-arguments. So they say first that the Geneva Court at least arguably does not have subject matter jurisdiction over the breach of duty claims. But on the evidence, and here I am referring to the Besson report at paragraph 49, that determining jurisdiction over breach of duties claims is a fact-dependent exercise for the purposes of PILA section 152B, and one that neither party's Swiss law expert really had sufficient time or perhaps information to undertake in the 2 days between when each was instructed and each produced their report. But on their own theory of vicarious liability, the claimant's own case is that the fourth defendant is responsible for the actions of the individuals in relation to BSA, wherein those individuals acted in their capacity of employees of the fourth defendant. So now that the individuals are in the process of filing their evidence, the evidence will be before that court. And on that evidence, it will, as we've discussed, show scant presence in the DIFC of 2 of the 3 individuals. I believe it would be nonsensical, Your Honor, to claim that either Mr. Sassoon or Mr. Astruc somehow reserved their alleged breaches of duty during the handful of times that they traveled to the DIFC, And even claimant's expert's own report notes that the place in which the person was when they conducted the misfeasance is a factor to be taken into determination by the court and may be determinative of the issue. And as to Mr. Carton, although he was living in Dubai, not in the DIFC, and maintained a workplace in the DIFC, his BSA employment contract incorporates by reference his employment contract with the fourth defendant and fully enabled him to share the confidential information that he is alleged to have shared as a matter of fraudulent breach. So second, claimants cite the Mr. Carton's employment contract. Now, there aren't any contract claims per se here that we identified, but in any event, we do note that it is relevant for what he was and was not able to do. Third, they cite the office holder claims. Now, as their own expert confirmed, the office holder claims can be brought in Switzerland following recognition proceedings, as we just discussed. And additionally, any uncertainty about whether a Swiss court would assert jurisdiction is on account of the factual nature of the inquiry and the dearth of time that the expert witnesses had with the file. This is confirmed by Mr. Besson, who, on the generalities of the Lalive report, agreed with it, but noted that the factual determinations were uncertain based on the limited facts available to them. And regarding tort, the claimant's own evidence shows that Swiss courts would have jurisdiction if Geneva were shown to be the place of the tortious act, which if Mr. Astruc or Mr. Sassoon were sitting in Geneva at the time, would be the case. Now, for all of these reasons, in addition to addressing the third factor cited by claimant in regards to Liz Pendens, we would posit that the court has enough to decide that Geneva Court of First Instance is an available forum for the purposes of the Spigliata test. Now, fourth, regarding Liz Pendens, the claimants denigrate the Swiss proceedings as an artificial attempt to establish jurisdiction. They also call it cynical and vexatious. And these adjectives appear to be an attempt to harness a historical distaste for proceedings seeking negative declaratory relief. But even their cited reference, Dicey Morris, at paragraph 1255, states that this attitude of outright hostility has now been replaced by one of neutral caution. And the referenced footnote there, which is footnote 201, then quotes a case which states, I can see no valid reason for taking an adverse view of negative declaratory relief, and goes on to say that in context, negative declaratory actions can and do have utility. Here they have the utility of being the mirror image of the claims later filed by claimants and covering off any other contradictory or deviating prayers for relief from the claimants. This is from the translation of the conciliation request, which is bundle J18, page 1233. Now, if the court here were to be as dismissive of the Swiss proceedings as the claimants invite it to be, it would only reinforce the policies that Switzerland has in protecting the sovereignty of itself and those within its borders by making such cases available. Fifth, the claimant's fifth argument regarding Liz Pendens. They claim that the time and expense of proceedings render Switzerland not to be a clearly more appropriate forum. In doing so, they claim it is common ground that the proceedings are unlikely to be resolved more swiftly in Switzerland than in the DIFC. Now, this point is meant. I'm sorry, Your Honor.
It was pretty clear that what one does not do is enter into any comparison of the way in which the courts conduct their proceedings. It would only be in a very extreme case that you took much account of the fact that it'll take a bit longer in one place than another, or differences in the way they approach evidence and disclosure and so on and so forth. The courts in England have been very clear about not trying to compare the relative procedures of one court against another, unless there's an allegation that one court won't do justice, and none of that applies here, obviously.
We agree with that assessment, Your Honor. Thank you very much. I wanted to address two factors that perhaps make this case a bit different from much of the case law out there that the claimants raised, and one being that this is a claim in an insolvency matter. But we believe that fares no better. They contend that the fourth defendant's submission of a proof of debt in the insolvency proceedings in the DIFC amounts to a submission to this court's jurisdiction for the purposes of fraud claims. Now, the claimants cite a number of cases in that regard, and all of the cases say the same thing. They all explicitly state that a creditor cannot use the courts of other jurisdictions as a means of gaining priority vis-a-vis the creditors who sit pari passu. We would contend that the leading case is Stitching Shell, and this is in the bundle at N82, page 4660, and I'm turning now to paragraph A.
Sorry, can you give me the reference again?
Sure, N82, page 4660, at paragraph A. Please let me know when you're ready for me to proceed.
Yeah.
What a creditor may not do is take any step outside the liquidation which will get him direct access to the insolvent's assets in priority to other creditors. This is because by proving for a claim A, he has submitted to a statutory scheme for the distribution of those assets pari passu in satisfaction of his claims and those of the other claimants. This doesn't say anything about submission. And actually, allow me to take a step back there. This actually makes a comparison between two different types of claims in which one results in a submission to the court's jurisdiction, and for other purposes, it does not result in a submission to the court's jurisdiction. We would submit that this claim here, the Swiss conciliation proceedings, are that sort of type B claims under the analysis in Stitching Shell. There's another case that I would like to turn the court's attention to when the court is ready.
Just bear with me, I'm just looking at yeah. All right. Where do you want to go next?
The NMC healthcare case, which is an ADGM case cited by the claimants. It is at bundle N70, page 4394, paragraph 3. The paragraph that we'll reference is on 4396. It's paragraph 3.
Yeah.
And this case, it's a little harder to orient yourself in because it sort of starts in the middle of the story, but this particular order rather relates to a contempt application in the context of a prior order in which an ADGM justice had ordered the respondents to cease from filing alternative claims in Dubai for the enforcement or execution of any debt or claim arising out of or in connection with the facility. It then carved out certain other types of related claims, but the prior order functionally did the same thing as the order in Shell, which is just protected the assets of the estate as they sat from an attempt to end run around the insolvency process.
Yes, what are you relying on in this?
So paragraph 3, we think, is the clearest, where it says that the respondent nor capital, whether by itself or its servants, agents, or otherwise, shall not commence or prosecute or continue any proceedings in any court or tribunal in the Emirate of Dubai for any enforcement or execution of any debt or claim arising out of the connection with the facility. We believe that that is indicative of the scope of the submission of jurisdiction to the ADGM. Like I said, when we first reviewed this case on claimant skeleton, it actually wasn't clear to us what they were citing it for, but we believe that it is useful to the court for this purpose.
Well, the question is what's meant by any enforcement or execution. What are you saying that means?
Well,
on the face of it, it looks as though it's saying that you couldn't issue a claim in a foreign court in relation to the debt in question. Is that what you say it does or doesn't mean? Or you do say it only applies to a writ of execution?
No, we believe it relates to the debt as well. We're
right. So what's the basis upon which that order was made then?
In the contempt application?
Well, what did Andrew Smith do when he made his order on the 5th of October? He was doing that on what basis? He was saying because there was an insolvency regime in Abu Dhabi, which had set up liquidation and so on of NMC, it wasn't permissible for any of the creditors who'd proved in the liquidation to go off and begin proceedings elsewhere. Was that what he was saying?
Correct.
And if so, why was he saying that?
Well, as we understand from the scant procedural history recited in this order, because that is exactly what the I guess respondents in this particular application were doing, and so a contempt order was sought against them for that reason.
Well, I understand that, and the question is, what's the basis of that? I mean, Andrew Smith, of course, wouldn't do that without having some legitimate basis, one would hope.
Quite right, Your Honor. And I'm going to apologize.
The point is this. Yeah. The point is this. What does submission of a proof of debt and a liquidation actually involve in relation to determination of the validity of the debt? That's the question, isn't it?
That is the question. I believe that is the question, Your Honor. Yes.
And what you're saying, as I understand it, is that that doesn't stop proceedings being launched for a negative declaration in relation to other matters.
Correct.
That are not actually the debt in question. I think that's what you're saying.
That is.
Is that right?
That's a proper summary, Your Honor. Yes, thank you.
Right. And is there anything in either of these decisions that goes to a wider submission to jurisdiction other than that in relation to the debt for which proof is sought in the liquidation?
Well, I would just say that in the Stitching Shell case, that there is actually a comparison made between types of claims, and that ones related to the debt are the ones wherein the submission to jurisdiction of the court is effective, and other types of claims, which are there described as type B claims, are not within scope.
Yeah, well, that's what you referred to type B claims earlier, but you didn't show me what was actually said about the difference between type A and type B claims. Can we look at that, please?
Certainly, Your Honor. May I just grab my case bundle? I truncated my notes a little too much, if you don't mind.
No, of course. So this is back to page 4660 or thereabouts, isn't it?
Correct.
I said once I haven't looked at the bits that are referred to in the footnotes in the in the claimant skeleton. So I need to be taken to those by one or other of you.
Certainly. So on page 4660 at the top, the first full sentence of A states
Is it easiest just for me to look at the head note first of all and just get the guts of it?
Certainly.
Okay, well, I see what the head note says. So where's the distinction between type A and type B?
So on page 4660, at the top of the page on paragraph A, the first full sentence, it states that the board would accept that the submission of a proof for claim A does not in itself preclude the creditor from taking proceedings outside the liquidation on claim B.
Right.
What it may not do is take any step outside of the liquidation, which would get it direct access to the insolvent estates.
Okay. All right. Thank you.
Moving on to just certain procedural difficulties that may be affected if we were to proceed in the DIFC. We don't mean to suggest that any of the defendants have an intention to be difficult with the court over disclosure, but we are just mindful that because the fourth defendant is a Swiss bank, that there are certain procedural requirements in Switzerland if any disclosure ordered relates to information covered by banking secrecy or confidential data as to the data privacy regime. And those particular categories of data may be subject to extensive requirements, including potentially the need for disclosure to go through diplomatic channels. And that certainly just may slow things down here. I mean, it bears mention that in anticipation of possible cross-examination today, both parties' Swiss law experts were required to obtain formal authorization from the Swiss Federal Department of Justice and Police in order to enable themselves to give evidence. And failure to do so would have resulted in potential criminal liability. So although because of, and thankful to post-COVID procedures, they were able to obtain that permission relatively quickly, and it came through earlier this week. That same cannot be guaranteed for certain categories of disclosure for which permission via diplomatic channels might be required. The other thing I would note on this particular issue is that Mr. Marron attempts to minimize this requirement by saying, for instance, that clients could simply consent to the disclosure of their data. I would like us to take a realistic view of that and think for ourselves, if any of our banks contacted us and said, I would like to disclose your personal financial information in the context of a litigation wholly unrelated to you, what our reaction to that would be. I certainly wouldn't check the box and turn the form back in, and I might change my bank. It would be an absolute albatross from an operational perspective if the court were to adopt that view. And this really is just a dedication to the adherence to the rule of law by the fourth defendant. We think that's something that the court would not want to discourage. Turning now
but
to
I think what you're saying in any event is that the position would be no different, whether in Switzerland or in the DIFC with regard to bank secrecy laws and so on.
The position wouldn't be no different, but I think that the procedural aspects would run a lot more quickly there because we wouldn't have to go through diplomatic channels.
Yeah, but we're back to the same point about comparing the procedures and so on and so forth. But yeah.
Surely. Now, turning to the second limb of the Spigliata test, the risk of injustice, the court is no doubt aware that the focus of courts when evaluating the potential for injustice is access to justice and rule of law. And in this regard, we believe that claimant's suggestion of potential injustice in Switzerland is frivolous. Switzerland is nothing if not a rule of law country. Spigliata itself mentions several prior cases in which forum non-conveniens was evaluated in relation to Swiss proceedings.
So I'm sorry, I may be able to cut this short. We've never suggested that there would be injustice before the Swiss courts. That
No.
You can't find that anywhere in our documents, and that wouldn't be a proper point for me to raise, so I'm not raising it.
Okay. Well, I would turn to the three other factors that claimants cite regarding potential for injustice, which are the ability to resolve all claims, the limitations, and funding. Now, I think that we already covered off the ability to resolve all claims, and as the court rightly noted, it gets to the substance of the claims and the issues, not a map of the claims one-to-one. And claimants' quotation, the BSA creditors are entitled to.
Can I just stop you there before?
Sure.
I'll come back to it perhaps at the end of your submissions, but the question of where the breach of duty is can be dealt with depends on the factors in part as to whether either the breach of duty or the damage occurred. That's my understanding of what the Swiss law position is. Have I understood that right?
Yes, Your Honor.
And that's a fact-dependent question where there is currently a degree of dispute.
That's correct as well.
So what is the court expected to do where it has a dispute that is not capable of resolving at this stage?
I don't believe that the claimants have put forward a credible argument that the substance of these claims cannot be litigated to completion in Switzerland. Again, it may be that they can't plead the exact claims that they want, but the substance can be litigated there, certainly with the activities of the first and second defendant on behalf of the fourth defendant almost necessarily taking place in Geneva. I believe here, though, they're making a bit of a different point where they say that the BSA's creditors are entitled to expect the BSA's assets will be dealt with in accordance with the statutory scheme applicable under DIFC legislation. Now, for us, this statement is just a transparent reference to the fact that BSA's only significant creditor is also its litigation funder. So, in other words, what they're really saying is that the litigation funder wants to be able to control the location of the claim. This is not an issue affecting the likelihood of injustice. In regard to the second factor that they cite, limitations, courts have given various treatment to this factor, with Spigliata itself finding it to be relevant only in circumstances where the claimants have acted reasonably in pursuing their claims. Here, limitations issues are a function of the claimant's 7-year delay in bringing claims, which claimants have not endeavored to explain. That is not an injustice. Third, in regard to litigation funding, the legal position on funding is that it can only overcome the prima facie case for a stay in exceptional circumstances, and that according to Dicey Morris, paragraph 1248, the court will conduct a searching analysis of all possible forms of litigation funding, or sorry, not litigation funding, forms of funding, in the foreign legal system, as well as their states England and of course here DIFC. Now here, all of the non-hearsay evidence available points to robust availability of funding in Switzerland, with copious options for commercial litigation funding and even legal aid potentially being available to corporations there. The liquidator underpins his argument only with his own unsubstantiated and self-serving statements, cloaked behind privilege. They should not be credited for this reason and instead should be stricken. Such an approach is consistent with RDC 2918 through 19. Now looking at the defendants and the claims against them in the round, not only is there risk, but certainty of parallel proceedings rendering inconsistent outcomes and the lack of risk of injustice. And so we would respectfully request the court to decline jurisdiction over the fourth and fifth defendants.
Okay. Mr. Shipchi?
Yes, my lord.
Over to you, I think.
Very good. Thank you for that. I have a few preliminary remarks before we dive into the detail. I'm very grateful to your lordship for the pre-reading, and it's clear that your lordship's very familiar with the case that's been put, so I don't need to develop that. Can I just mention something about the parties? I know you'll be familiar with this too, but these are DIFC-centric parties. The claims, of course, have been brought by a DIFC company in compulsory liquidation supervised by the DIFC court, alongside a DIFC liquidator who is an officer of this court. And as for the defendants, the first to third defendants were individuals involved in this fraudulent scheme that we allege. The first and second defendants were directors of Bank Sarasin-Alpen, and the third defendant was its CEO. And as my learned friend accepted a moment ago, that CEO was based, a resident in the DIFC. So that's to say that all of the individual defendants were directors or officers of a DIFC incorporated company. As for the fifth defendant, that is also a DIFC entity. That is the company to which we say the business was improperly diverted. For the court's reference, the first and third defendants were also directors of the fifth defendant for some of the relevant period. And then finally,
which defendants?
Oh, sorry, that's the first defendant who was a director from April 2015, and we plead that in our consolidated predictive claim at A3, page 33. And the third defendant was a director from March 2015, and again, it's pleaded in the same place in our consolidated predictive claim. And then for the fourth defendant, yes, of course, it's a Swiss bank. But it was the majority shareholder of Bank Sarasin-Alpen, and it is 100% shareholder of the fifth defendant.
Yeah, well, I've got all that. Yeah,
I'm grateful. So we'll come back. We'll come back to the events in the law later on when we look at Spiliada. But the submission I will be arguing before your lordship is that when one looks at the parties, when one looks at the events, and one looks at the applicable law, all of it has a very heavy DIFC complexion. Now, there were just two other preliminary points I wanted to make. One does detect during the course of the defendant's submission some criticisms of the liquidator. I don't want to get into that in any detail, but just to make it clear, the liquidator is an officer of this court, and the claims that he is bringing on behalf of the insolvent estate. And in everything he does, he is subject to the supervision of this court. And his claims have been brought out of lengthy investigations that he has carried out. And these proceedings have been started in the exercise of his professional judgment. And as your lordship will note, the pleadings themselves make allegations of fraud. We recognise that those are very serious allegations that should only be made on a proper basis, but they've been settled by counsel, and we consider that they have been properly made. And then my final point that I just wanted to address were the conciliation proceedings. Now, I'll look at these in a bit more detail later, but our overarching point is that these proceedings have been issued with the objective of spoiling the DIFC proceedings, and they're not driven by any serious desire on the part of the defendants to advance this case. And we say that based on 5 factors. The first is that in February 2022, when we sent our DIFC pre-action letter, Clifford Chance, acting for all the defendants, responded. And at the beginning of their letter, they said in particular that they reserved their position on costs in relation to what we were doing in the event of any premature issue of proceedings. That was their language. And that's in the bundle I, tab 12, page 817. And that was, we say, designed to discourage us from issuing proceedings ahead of any settlement negotiations. And of course, that's the effect that it had. Now, thereafter, the parties entered a standstill agreement and we sent them the draft predictive claim in April 2022. And then the parties entered settlement discussions, which ultimately came to nothing. That was my first point. My second point is that the Swiss conciliation proceedings were filed nearly a year after that pre-action letter and during the currency of the standstill agreement. Now, I don't say that it was a breach of the standstill agreement for them to do that, but I do say that at no point prior to the issue of the conciliation requests did the defendant send any pre-action letter for those proceedings or give any notification that they would be commencing those proceedings. And that is a significant point. My third point is that the Swiss conciliation proceedings are a set of proceedings in their barest form. They contain no particulars of the facts or the causes of action or the party's position. There is no articulation at all of the defendant's defence to these claims. In fact, we've learned more during the course of today's submissions about the defendant's defence than in any of the documents that they have filed so far in these proceedings. All they say in the...
Presumably I'm entitled to infer from the fact that there were without prejudice discussions taking place over the course of a 9-month standstill agreement, that there would have been some discussion of the merit. It seems inherently likely that that would take place, but I obviously can't make any findings without evidence.
No, and I think that would be a perfectly reasonable assumption to reach, but that's not the point that I'm making. The point I'm making is that if the defendants were serious about these Swiss proceedings and serious that that was the proper place to conduct this case, one would see some real effort on their part to try and advance the Swiss proceedings and ensure that it properly encapsulated the issues between the parties. Now, that's slightly difficult.
That's slightly difficult, isn't it, Mr. Shipji, in a circumstance where what you're seeking is a negative declaration. Mr. Martin says I shouldn't draw any inference from the fact that one party is simply seeking a negative declaration and cites some authority to that effect. But it's perfectly plain that if all you're doing is saying I'm not liable, in reality, you don't want a case to take place anywhere.
Well, I mean, that's
almost inevitable, isn't it?
That's let me put I understand that submission. I think I'm making a slightly different submission. In the negative declaration proceedings that I've been involved in common law jurisdictions, where one is the applicant, one would plead out the nature of the case, the various issues in dispute, and set out the basis on which you say that you're non-liable. And in English proceedings, I've done that even in Part 8 proceedings, but I've done it with a pleading that actually sets out what the issues are quite clearly for the court to understand what needs to be determined. Now, for the conciliation proceedings, they're at an anterior stage. The conciliation proceedings are effectively a pre-claim mediation procedure. And so I understand that to initiate that, you don't have to do very much. But if the defendants were serious about litigating in Switzerland, they would be saying, look, we've already drafted the claim documents because it's obvious this case the conciliation proceedings are not going to work out. This case is going to go to litigation. Here, we've drafted the claim so that the DIFC court can see in more detail what the issues will be in the Swiss proceedings, what the applicable law will be, and what the Swiss courts will be asked to deal with. And we say one of the problems with their approach is that the DIFC court has no comfort at the moment that even the substance of the dispute will be captured properly by the Swiss proceedings, because it's entirely in the defendant's gift as to how they plead that case. And at the moment, they have remained tight-lipped on it. So it's just the most that can be said is that they've started a conciliation request in response to our letter of claim, saying that they're not liable, but it is entirely down to them then how they choose to pitch those proceedings in terms of its content and scope. And that brings me on to my next point about the conciliation proceedings. Even after the issue of those proceedings, we were notified of the issue of them after the event, shortly after the event. But it took them 4 months after the issue of those proceedings even to give us a copy of them informally. And even then we had to ask for them. And then my
Your
final
Honor,
point.
May I interject on that point that we provided them within days of them being asked for. So it was months later that they first asked for them, and within days that they were provided by Lenz and Stellen.
Yeah, well, as they're not very informative, it doesn't help much anyway, does it?
No, but
Anyway, there we are.
But that, I mean,
it's a small point in the overall scheme.
What we say, though, is it's a further evidence of them not actually genuinely wanting to press ahead with the Swiss proceedings. And that brings me on to the final point, is that your lordships already had to deal with their stay application, the fifth defendant stay application. Now, that application was issued, had supporting evidence. We responded. There was reply evidence. In the original application and the original supporting evidence, there was no mention of the Swiss conciliation proceedings. And we say that it is also really striking. You would have thought the first thing the fifth defendant would say to this court is, this is the wrong place. These proceedings shouldn't go any further at all. They should simply be dispensed with because we are all litigating in Switzerland. And instead, what they did sorry, Mono.
Doesn't take you very far. I mean, they made the point that they were making an application on a case management basis, and there was every likelihood that a lis alibi pendens form conveniens argument would be raised. I was aware that that was likely to happen at the time of the case management stay being granted. So they were trying to keep their powder dry. You're entitled to say the object of all this is delay, but you know, that's as far as the point goes, isn't it?
Well, so I do say the object is delay, but the point I was making is that the existence of those Swiss proceedings came to your lordship's attention because of our evidence and answer, not because of their original application. And yes, of course, once we had raised it, they came back and said, there are these proceedings, we will be running a lis alibis pendens point, but that's not for now. But my complaint is not about that. My complaint is if they thought that this was a knockout blow, it was the genuine answer, you would have thought that was the first thing that they would say to this court, and they didn't. Instead, what they were trying to do was delay the proceedings for 6 months, and they gave all kinds of reasons, including needing to coordinate defences. Anyway, those are my preliminary points, my lord. I won't dwell on them, but we just think they're useful context for examining then the objections that come up. There are 3 lines of attack run by the defendants. The first is the fourth defendant's point about service in Singapore. I don't think I need to say anything about that. They haven't disputed service either under DIFC law or Singaporean law. So it seems to me that that point is a dud one. I do have some submissions if your lordship would like to hear them, but I don't want to waste the court's time.
Well, I've already effectively made a ruling on that. I shall give further reasons in due course, but they can be pretty brief. So I just don't think any of the arguments go to the point, the points that matter, which are, as you say, the question of legitimacy of service as a matter of DIFC law and Singaporean law. What the impact may be in the long term on enforceability, well, that's the question for another day.
I'm grateful, my lord. So let me move on then to the second line of attack, which is the lis alibi pendens point.
The only point that arises from that is that in the context of lis alibi and forum non conveniens is that we now have 2 defendants who've been properly served. and we've got two defendants who've been properly served as a matter of statutory jurisdiction of the DIFC. And this does raise the point that I asked Ms. Martin about. The Spiliada type cases all start off on the basis of a distinction between service as a matter of right and service as a matter of discretion out of the jurisdiction. But the DIFC jurisdiction knows no territorial jurisdiction as such. It operates on the basis of statute, and if you fall within the statute, then the court has jurisdiction. And the question then arises, well, if that's service, quote, as of right, because you fall within the statute, although the court obviously has a discretion whether or not to exercise that jurisdiction on forum convenience grounds, where does the burden lie? The distinction, as you know, being between where services of right, the burden is on the other party to show there's a more appropriate forum in the interests of justice and convenience of the parties, or whatever the expression is. But where service is not of right, then the burden essentially rests on the person serving. And I ask the question, how does that work in the DIFC context? Is there any authority on the point? And does it really matter?
So I think answer all of that. The first point is that you're in the DIFC, as you say, has a much broader scope as to where you can serve as of right. So we say this is an as of right case, and that as a result you would treat this as an as of right case for Spiliada purposes, and not examine it like as the English law question of whether you should be granted permission to serve out. And I'll take you in a moment. I'll take you to the DIFC authority on the point. And my learned friend also accepts that analysis, and it's set out in their skeleton as well. And I'll take you to that. So that's the point on the burden. I do actually agree with I think the sense of what your lordship is asking, which is, does it make a difference in this case? I don't really think it does. In some cases, it might be a bit more balanced. And certainly we were looking at, I think, the KBC case, which is cited in my learned friend skeleton, which is the case that your lordship decided. And there it did look like, as I understand your lordship's analysis, that some of the factors were quite balanced. And then your lordship looked at the concern about multiple proceedings being one of the factors that was more significant. But we say that this is a case where there is no, the scales are very heavily weighted in favour of the DIFC, and whoever has the burden, whether I do or my learned friend has, we say the answer would be the same. So if I may just go back to the authorities, perhaps we could start with the Pro Viti case, which is in your bundle in N tab 72, page 4451. This is the decision of the DIFC Court of Appeal, and it's a judgment of Sir Richard Field. And if we could pick it up at paragraph 21, please.
Sorry, and page again.
This is 4451. And we will come back to some of these forum authorities in a bit more detail, because I do want to address your lordship on the relevance of lis pendens for forum purposes. But just at the moment, keeping it basic and sticking to what the test is, at 21, Sir Richard Field explains that where issues of FNC have arisen in the DIFC courts, they've been addressed by reference to FNC founded on the decision of the House of Lords and Spiliada. Yeah. And then he goes on, I think, in paragraph 22, to set out what the key principles are. And I think actually it's a very, for our part, very helpful summary of what the law is. But it's 22.2. He says there generally the legal burden is on the defendant to persuade the court to grant a stay. And then he says, but if a party relies on a certain state of affairs in advance of his case, he'll be under the evidential burden of proving the same. And then he goes on to say, number 3, the burden is on the defendant to show not only that the forum chosen by the plaintiff is not the appropriate forum, but also that there's another forum which is clearly or distinctly more appropriate. So we say this is the traditional application of Spiliada to cases as of right. And that is an analysis that my learned friend also accepts in her skeleton argument. And that is at bundle M. And
sorry, what am I looking at now?
This is my learned friend's skeleton argument on jurisdiction. And that's bundle M, tab 1, page 3027. And she agrees with me there. She said, refers to Spiliada, says it's been adopted by the DIFC courts. She actually refers to the Pro Vita case as well. And then she says the first stage is that the defendant must show another available forum. So, I mean, as I said, on this case, I don't think it makes too much difference, but I think that is the right approach.
Yeah.
My lord, can I just go back to talk about lis pendens, and then I will come back to talk about forum. I mean, I'm in your lordship's hands, but I think.
Well, I don't think I need a lot of being addressed much on lis alibi pendens, in the sense that, you know, I mean, this is an area of law that I was extensively involved in at the bar. I'm clear in my own mind, unless there's anything further you want to add, that lis pendens is simply a factor within the context of forum convenience. I mean, there was a case that went to the Court of Appeal called DuPont and Agnew, where all these factors were laid out in the context of stays being sought of English proceedings and Illinois proceedings, if I remember rightly, and anti-suit injunctions being sought in each jurisdiction against the other. So it's multiple litigation in both Illinois and the UK, with each side seeking, first of all, to stay the one they didn't like in the jurisdiction they didn't like, and then seeking an anti-suit injunction or TRO in the States. And both courts decided that they had jurisdiction and they thought they were suitable. And there was then going to proceed what is often described as an ugly rush to judgment. You know, this is all perfectly possible. It's not desirable, but one would like to avoid it if possible. But there are cases where it simply isn't possible. And as I've understood both parties' stance, and they can each tell me if I'm wrong about this, but what I've detected so far is each party saying that they are unlikely to take part in any proceedings in the jurisdiction they don't like. I've read that out of the submissions of the defendants, but I've also seen it in the submissions of the claimant, that if the matter proceeds in this jurisdiction, the DIFC, the defendants are unlikely to participate. And if the matter proceeds in Switzerland, the claimants are unlikely to participate. So we look as though we may very well get to the DuPont and Agnew position if there are no successful applications for a stay or dismissal, or successful applications for an injunction, which are much harder to get in any event. And, you know, that's maybe a position one has to live with, but it's unfortunate. So lis pendens, particularly in circumstances where, however you look at it, neither case has got very far yet, and the timing and so on, therefore, is not really very relevant as to who began first and how long does it take to serve, and parties playing games about not being willing to accept service and so on and so forth. You know, everybody is adopting a forensic tactical approach for the purpose of what they think their client's best interests are. And none of that is relevant, really, to the decision that I have to take. The decision at the end of the day is going to be a forum convenience case on the basis of historic connecting factors and what ought to be, as the House of Lords described it, a summary disposal on a nice, short and succinct basis.
Well, I'll try. I know your lordship's right. Summary disposal is the paradigm, but one often doesn't quite get there because it gets knotty. But I'm going to try. I'm going to try to keep it quite helpful, and I think that's it's helpful to hear what your lordship is considering on that. On the list pendants point, the only point that I wanted to deal with at this stage was just my learned friend's submission that somehow the Brussels regime is a matter of DIFC law. It's just a not properly arguable point. That's just wrong as a matter of analysis. The English position arises out of treaty obligations. It's not even the English position anymore because we have left the European Union. The common law, as your lordship says, just takes lis alibi pendants as a factor. My learned friend raised a point about reflexive effect. Your lordship will know more about this than I do in Forexpo, which wasn't in her skeleton. It's not even in the authorities bundle. It's a totally new point, but it's a bad point because it would be one can see the force of the point if proceedings have taken place and are on the move and advanced and so on and so forth. There's an obvious benefit if the thing is up and running, but the fact is that we're at the early stages in either court, so there it is. It doesn't help very much, therefore, just to look at who was first seized. That's right, and there's also it may be unduly technical for our purposes, but the reflective application of EU treaty obligations arises from the fact that you are a party to that treaty, but the technical terms of that treaty don't actually apply on the facts, and so it's a small extension to keep with the spirit. Yeah. Here, the UAE isn't even a member, so those treaty obligations are just irrelevant. And that argument has been tried before, that argument that some of this EU law forms part of English law and then ought to be carried into DIFC law, and that's been rejected in the IDUPL case. But I don't think that is even my learned friend's argument. So I think I don't intend to dwell on that. I think in light of your lordship's observations, I think the main event is forum non-convenience, and that's really where I should go next.
Please.
Your lordship is very familiar with the principles. I'm not going to dwell on them. I just wanted to identify some points of emphasis. As we see it, one of the court's aims in making an assessment for forum non-convenience purposes is trying to decide where the trial of the action, trying to ensure that the trial of the action takes place in a location where it can be tried most suitably for the interests of all parties and the ends of justice. That the focus is ultimately to make sure that trial happens in the right place so that justice can be done, and that's justice for all parties. Now here there are interests in this litigation that go beyond the mere parties litigation, because we represent the insolvency estate. Now, my learned friend tried to make some point about the principal creditor. I don't accept that. Our obligation is to act for the purposes of the entire insolvency estate, and it's that master that we serve in bringing these proceedings, and that, I say, is also a factor in deciding where the right forum for trying the action is. We'll come on to deal with list pendants in due course, but I wanted to start by considering the question of whether Geneva is even an available forum, which is the first part of the first limb of the Spiliada test. Now, I'm focusing here on Geneva. In some cases where there are no extant proceedings, there might be a more general debate about whether the courts of a particular country are more appropriate than the DIFC court. But in this case, my learned friend has really stacked everything on the Geneva court, because that is where she has already commenced proceedings. And that is quite significant. We think the court should focus on whether the Geneva court is the appropriate forum, because it's no answer for my learned friend to say, oh, well, maybe Geneva can't deal with this, but Zurich might. And we say that's particularly significant when one starts to look at whether the Geneva court has jurisdiction on these categories of claim, because certainly, we think the most stark example is the director's liability claims. There, we don't think there's any proper arguable basis that the Geneva court has jurisdiction. And I wanted to examine the defendant's evidential case on that to show why it doesn't work. So the first question we're going to look at is, is the Geneva court an available forum for the director's liability claims? And we say that a lot of this case is about director's liability. It's looking not so much at the cause of actions, but looking at the substance of what this is about. We say our own officers and directors acted in breach of their duties to us. They misappropriated business that was properly ours and diverted it to the fifth defendant. That's a significant part of our case. Now, the defendant's Swiss law expert accepts that the Geneva court can only have a jurisdiction in relation to the director liability claims if Bank Sarasin-Alpen's business was administered in Geneva. So this is not a point about where the torts occurred. This is a separate question. Does Bank Sarasin-Alpen, my client, was its business administered in Geneva at the relevant time? And I want to take you to the Swiss law experts' evidence on that, because there's actually no dispute between them on that key issue. I'll show you our report first, which is at tab 11, page 446.
I printed some of this stuff off, so I can be slightly quicker at getting there than having to go through the search function. But page 446, yeah.
Yeah, it's page it's paragraph 65 and 66. Could you just read those kindly? It's particularly 66 I want to focus on.
This is Mr.
This is our expert.
Yes.
So his punchline is pretty stark. He says Swiss courts don't have jurisdiction to hear the negative liability claim in relation to the director's claims. Now, the defendant's evidence says that there's a caveat to that. So let's pick that up. That's page 481. This is Mr. Bessont's report. At 48 and 49.
Yeah.
So he agrees with us, but on 66, he says it's too categorical. And then the point he makes is the Geneva court could have jurisdiction based on Article 152B of PILA in the event that BSA, it's my client, is found to have in fact been administered from Geneva. And he says quite rightly that he doesn't have enough information. And of course, it's not for him to actually make that assessment. It's for your lordship. Now, in our skeleton, if you have your R skeleton available, paragraph 51, which is page 3057 of the bundle.
Yeah.
We summarize there what we say is compelling evidence that BSA's business was administered in the DIFC. It's where it was incorporated, where its operations ran, where most of its staff were based, where its head office and register office were located, where it was regulated by the DFSA. And we also point to the shareholders agreement, of which the fourth defendant is actually a signatory, in which the fourth defendant agreed that the management and control of Bank Sarasin-Alpen should be exercised in the Emirate of Dubai. And the shareholders should use all reasonable endeavours to ensure that the company is treated for all purposes, including taxation as resident in the UAE. So that's as we summarise.
I had a discussion with Ms. Martin about board meetings. One would have assumed, therefore, that the ordinary position would be that board meetings would be in the DIFC because of its incorporation and so on and so forth. But there's no actual requirement for that, is there? As a matter of company.
Can I just check that point? I need to look at the often there's a provisional in the Articles of Association that say that where a meeting, because it does sometimes matter where a meeting technically took place, even if it took place by phone, and sometimes there's a provision which says that if it's by phone, the deemed place of the meeting is the company's head office. But I just the articles are actually not in the bundle, and I don't want to stray too much off the topic, but we will have a look at that. It may be that they don't assist, but I mean, for today's purposes, your lordship can only go on the evidence before you. Yes. And I want to look at the evidence. We had quite a lot from my learned friend orally about what happened, but her oral submissions went beyond what her evidence says, and your lordship can only proceed on the evidence they've chosen to file. And I want to examine all of the references they've given, because we say that it's quite clear that they can't even manage an argument to say that BSA was administered from Geneva. So let's look at that evidence. That's in Mr. Devenish's 5th statement, which is page 465 of the bundle. My lord, I'm just going to put you on mute for 10 seconds to ask my junior just to look at that point about the articles. And
well, not just the articles, but also the Companies Act in the DIFC, in case there's anything in that. I'm not sufficiently familiar with it to know.
I will examine that. If there isn't an easy answer, I may not be able to answer it today, but I will have a go. So we were looking then at Mr. Devenish's evidence on this point about the administration of BSA. He deals with it very lightly. This is page 465, paragraph 31.4. And he says key events, including many of the events purported to have occurred in relation to the alleged scheme, were undertaken in Switzerland, including in Geneva, as partially detailed in my second witness statement. Now, I haven't found anything in his second witness statement which indicates that BSA was administered in Geneva, but if my learned friend has more references, she can give them and we can look at them. And then he goes on at 31.4.1 to say the 4th defendant has confirmed to me that relevant general meetings of BSA shareholders were attended by representatives of the 4th defendant in Switzerland, including in Geneva. Now, that seems to be a point about where the people attended from, rather than where the meeting took place. He only gives one reference to a board meeting, and that document is in J111194. And that meeting note says right at the beginning, on this 14th day of May 2014, the shareholders of Bank Sarasin-Alpen Limited, the company, met at the appointed place located in the registered office of the company at the DIFC. Now, Mr. Carton, if you go down the page, Mr. Carton, one of the defendants, was present in the meeting. I can't see anything on the face of this that says that anyone joined by telephone. But again, my learned friend will correct me if I'm wrong about that. But certainly, I mean, and it also says that Mr. Astruch in the middle of the page, that he chaired the meeting. So I can't see anything.
We've confirmed that those events took place from Geneva, and my apologies for the belated provision of information that will be filed with the court today. It's just we're obtaining new information now that we have been retained by the individuals.
So, I mean, all I need to say on this, my lord, is that it's obvious that the meeting took place in the DIFC. It's not clear from the face of the document anyone joined by telephone, and if so, where they joined from. But even if they did join by telephone Geneva, there's no proper argument that meant that the business of Bank Sarasin-Alpen was being administered from Geneva.
May I just bring to the court's attention that this is an extraordinary general meeting of the shareholders. This is not a board meeting. This is not internal to BSA.
I'm so sorry. Thank you. I apologize. Let me just check. I'm so sorry about that. She's right about that. Let me just check though what the reference. Maybe I got it wrong from Mr. Devenish's evidence.
Well, it's
I'm sorry.
31.4.1 that deals with general meetings, of which this is one example,
Yes,
and
no, I'm so sorry.
31.4.2 that deals with board meetings.
That's right. I'm so sorry. She's absolutely right. So I took you to the right reference, but I misdescribed it as a board meeting, and it was a general meeting.
Yeah.
But that is the evidence in Mr. Devenish's statements. In fact, that's the only evidence he gives in this statement about an event concerning the administration of BSA taking place in Geneva, and the reference he gives is that general meeting note. And it's clear from that general meeting note that that meeting took place in the DIFC. And there is no other reference that we have found in Mr. Devenish's evidence that concerns the administration of BSA that supports the submission that it was administered in Geneva. Now, I want to look at my learned friend's skeleton argument next on that. And that is paragraph 87 of their jurisdiction skeleton, page 3030. And if your lordship could read 87, and then we'll just pick out some points.
Yeah. Yeah.
So the third sentence is hitting this point about jurisdiction over the director's liability claims. And he says the individual defendants took the pertinent decisions concerning C1 either within or from Switzerland. Now, he doesn't actually say Geneva there, he just makes a more general point about Switzerland. And then if you look at the footnote reference 55, the only reference he gives is to his expert evidence. He doesn't give any reference to any of the factual evidence. And then the final two sentences, he says, many of the board meetings were held in Switzerland. Well, we don't accept it was many. He's identified 2. But in the bundle, we've identified at least 3 that took place in the DIFC. And I'll give you the references for those. That's J6 1130, J9 1173, and J10 1182. And your lordship's already seen that general meeting which took place in Dubai as well. So they haven't provided any evidence to show that BSA was administered in Geneva. And that is fatal for the jurisdiction of the Geneva court on the director liability claims.
Can I just ask the last sentence? Many of BSA's board meetings were held in Switzerland, including on, and then the footnotes that are given to J5, J8, and J14.
Yes, I'm sorry, I took that quite quickly. Those 2 meetings were held in Zurich.
That's right. That's exactly the question I was going to ask.
Yeah, I'm sorry. I think I did come out, but probably in slightly garbled fashion. That was the. I was saying we accept that there were these 2 meetings that they've identified in Zurich.
Yes.
But nothing in Geneva, and even then, it's a stretch to say many of BSA's board meetings were held in Switzerland. They've identified 2, and as I said, there's at least 3 in the bundle in the DIFC. So that statement doesn't help them at all for the jurisdiction of the Geneva courts. And then the final statement is about general meetings, including the one on the 13th of August 2014, and they say that was attended from Switzerland. And that is, let me just grab that, that's page 1203. And that, again, that was a general meeting. That was actually the August 2014 meeting, which also took place in the DIFC.
Yes.
Yeah, and Mr. My learned friend, Mr. Sampson, just reminds me that we were looking earlier on at that May 14 note of the general meeting, and that of course was a DIFC general meeting as well. So we say there is compelling evidence that the administration of BSA was conducted in the DIFC, and there is no credible argument, not even an argument, that BSA was administered in Geneva. But even if there was an argument, the burden under Spiliada first limb would be on my learned friend to show you that there was enough of an argument for the court to reach the conclusion that Switzerland, the Geneva court, was clearly and distinctly the more appropriate one, and we say they can't get near that. So those are the director liability claims. There are two other heads of claims that we want to address. I'm going to deal with them more quickly. Firstly, there's the tort claims, and there the question of whether the Geneva court has jurisdiction is whether or not the facts or events giving rise to the damage took place in the locality of the court, or the damage was occurred in the locality of the court. And we say, and I'm going to deal with this at a fairly helicopter level, but we say, just looking at the sense of our case, it is a claim about the diversion of a business operated by a DIFC registered company in the DIFC, the diversion to another DIFC company. And we say that the key events took place in the DIFC. And that is what we have already pleaded. Our pleadings allege that the scheme was, we say, primarily executed in the DIFC. Now, Mr. Devenish in his evidence tries to point to various events that he says took place in Switzerland. He refers to BSA's internal, Bank Sarasin's internal records in Switzerland concerning client accounts. He talks about the sale of financial products by Bank Sarasin. He talks about client assets being booked in Switzerland. None of that cuts across my point that the scheme that we're complaining about was primarily executed in the DIFC. And the fact that these clients used the Swiss bank to hold Swiss assets is neither here nor there. That's not our complaint. Our complaint is about the loss of that business. We say that properly analyse the acts or events giving rise to the damage and the sustaining of that damage occurred in the UAE, specifically the DIFC, such that the court should think there is at least a serious argument about whether the Swiss court has jurisdiction over the tort claims. And then finally, on the insolvency claims, we are bringing office holder claims under DIFC law. They're provided for under DIFC statute as a class remedy for the insolvency estate. Those claims are not available in Switzerland in a comparable sense. In particular, there is no equivalent to the fraudulent trading claim, which we say is a powerful weapon given to DIFC liquidators. In relation to the transaction avoidance claim, which is a claim we bring against D5, there is a Swiss equivalent, albeit that actually the Geneva court would apply Swiss law to that, and that applies different time limits such that the claim would not actually be available. But we say, again, stepping back and looking at the totality of what we're doing, you cannot say that the equivalent substantial dispute on the insolvency claims could happen before the Geneva court. It would be a very substantially pared down claim. So that fairly swiftly addresses the question of whether the Geneva court is even available. We then move to the second part of the first limb of Spiliada, which is an examination of the connecting factors. And we accept on this that the court's approach isn't prescriptive. This is discretionary, that in different cases, different factors will have greater significance. But I come back to the point I started with. The aim of all of this is to make sure that the trial happens in the most appropriate place in order to do justice and for fairness of all involved. Now, there were 6 grounds identified by my learned friend in her evidence. Some of them weren't pressed in argument. I'm proposing to take them fairly swiftly, but we might dwell on a few of them. The first ground they identified were the strong connections with Switzerland. And we say that this submission doesn't bear scrutiny. In fact, it wasn't, I think, pursued by my learned friend orally. I started with the strong connections between the parties and the DIFC. I mean, in essence, the individual defendants signed up as either directors or officers of a DIFC entity regulated by the DFSA. And the fourth defendant signed up as the shareholder, majority shareholder for BSA, and 100% shareholder of D5, a DIFC entity. So they have all shown, we say, serious commitment to doing business in the DIFC, and that carries with it supervision by the DIFC courts. And so there is a very strong connection for people who decide to do business in that way with this court. The second point that my learned friend relies on is she says that key events in relation to the scheme were undertaken in Switzerland. And we say that's not a fair reading of the case. Now, on this, the defendants have chosen not to put in evidence any defence that they'll be running to the proceedings. So on the usual Spiliada proceedings, the court has to proceed on the basis that trial will involve the claimants proving their case. And that's what the VTB and Nutritech case says. Of course, that's still a significant burden on us. But in terms of your lordship assessing what trial is going to be about, it's going to be about proving our case. And if they had put forward a basis for defence, then that might make the court's inquiry a bit broader, but they haven't done that. And we say, looking at proving our case, it's very clear that this is a DIFC-focused case with DIFC events at their heart. And your lordship can pick that up from paragraph 11 of our summary of claim, and that's page 14 of the bundle. I'd just be grateful if you could read that.
Yeah, well, I'm familiar with that. Thank you.
So that's the second point. Then let's move on to the third point, which is about the proof of debt. Now, I accept this is a slightly more sophisticated point. Your lordship, it does involve a bit of examination of the authorities. In the Stichting Shell case, my learned friend relies on that sentence about the difference between claim A and claim B, but I don't understand there to be any analysis which explains what the distinction is in that authority. And so in my submission, it doesn't get my learned friend very far. I think what it indicates is that there may be circumstances in which a claim is sufficiently distinct that the submission by a creditor in a liquidation doesn't prevent that party bringing proceedings in relation to that distinct claim. But that isn't this case. And I wanted to look at the Erster Group Red October authority, which I think is a bit more illuminating on this question. And your lordship will find that at N36 of the bundle 3563. And perhaps I could just sort of pick up the material events. So starting with paragraph 9, the bank was added to the list of creditors of the first defendant, which was insolvent and subject to the supervision of the Russian court. It's paragraph 9. And then
Right.
at paragraph 10,
sorry.
I'm so sorry. I'm so sorry.
Right.
If I let you read maybe 9 and 10, and then I can pick up my submissions.
Thank you. Yes, I can't say I've picked up all the details particularly clearly as to who was what.
I know, but that, I mean, that's one of the, I think, challenges with unpicking authorities like this. Perhaps can I take you to a couple of other passages which I'll ask you to read.
Yeah.
And then I'll explain how we see the landscape here. So if your lordship could go ahead to page 3581 and look at paragraph 51.
Yeah.
And then if your lordship can go forward to 59, please. And read that as well.
'51 is very wide, isn't it?
It is very wide.
Requires the creditor to have all questions of whatever kind as against the debtor resolved within the insolvency as administered by the court of the jurisdiction. Yeah, what's 59 next?
Yeah, 59 is then dealing with the facts of the particular alternative claim that was brought and right, whether it's different. And so if you could look at that as well.
Yeah. Well, I understand all that, but I'm not sure I see how that helps you.
Your Honor, with apologies without making this a long reading exercise, but may I also direct the court's attention to 52, 53, 55, and 56.
Yeah.
So I'll make my submission about how you apply this principle here. So in our action, we are seeking to use, amongst other things, the DIFC court's insolvency powers to reconstitute, claw back assets that belong to the company. And we are using the insolvency framework under DIFC law to do that, including office holder claims. In terms of the fruits of any recovery, the fourth defendant will participate in them if its proof is allowed. So it is proved. It has asked the DIFC courts to deal with the liabilities of the company, and the DIFC court has jurisdiction over that. But as regards the assets of the company, it is seeking essentially to deprive the DIFC courts of that, and instead push that question before the Swiss courts. And we say that these authorities don't allow them to pick and choose. You can deal with the liabilities, but you can't deal with the assets. And we say, in light of that connection, and in light of the close connection between our liability, alleged liability to them, and our claims against them for misappropriation of our assets, we say they are stuck with us for both the assets and the liabilities question.
What would happen if there was a contract claim with an exclusive jurisdiction clause in it in favour of another country.
Someone will quote me if I get this one wrong, but I think that exclusive jurisdiction clause I think the submission to the jurisdiction would trump the exclusive jurisdiction clause. So they would up to the point where they don't prove in the insolvency, they could say, I've got my exclusive jurisdiction clause, you, the company, are stuck with it. But I think the second that they prove, they waive their right to rely on that exclusive jurisdiction clause.
I have some vague recollection of coming across this in the context of the Icelandic banks when they went down the tubes, and there were all sorts of swap contracts that they'd entered into in the UK that I had to deal with in the commercial court. But I'm blowed for the life of me if I remember what the result was. I have a sneaking suspicion I gave judgment in favour of whoever it was against some of the Icelandic banks, but whether or not they had proved in the liquidation, of course, I really have no recollection at all.
So I like you, I had a pretty heavy involvement in that world for a while, and I without going back and looking at the work that I did and other authorities, I'm hesitating to say anything more. I mean, I don't think that's a close analogy, is the short answer, because here obviously there is no exclusive jurisdiction clause. In fact, the only exclusive jurisdiction clause is that the employment contract for Mr. Carson has a exclusive DIFC courts jurisdiction clause. But the
essence of your argument is that although the authorities only refer expressly to the claims which are being pursued in the liquidation as being substantially the same as those then which are sought to be produced elsewhere, and the courts say you can't do that, which is obvious in a sense, that running a negative claim for a negative declaration in another jurisdiction in relation to the claim by the company in liquidation is equally not open to it. And there's no direct authority for that, as I understand it, from what you're showing me. The only relevant paragraph that goes as wide as that is that one to which I drew attention, which I think was 49, was it?
I think 50. I think it was 51.
51, that's right. All questions of whatever kind as against the debtor resolved within the insolvency. And you say because they're dealing with assets and liabilities, they're all within the insolvency regime. It would mean that any claim that the liquidator chose to advance against any creditor who had sought to prove in the liquidation would have to be resolved in the DIFC if that creditor had sought to prove in the liquidation. If he hadn't sought to prove in the liquidation, and maybe if there was an exclusive jurisdiction clause in the contract, the liquidator might be bound by that.
Yes, I mean, I'm hesitating to go too far on this because it seems to me I don't need to. I mean, the way I would put it is they have signed up to participate in the DIFC insolvency statutory scheme, and they get the benefit of that if their proof is allowed. And what you can't do is pick and choose and say, I like the DIFC when it comes to determining the liabilities of Bank Sarasin-Alpen and money that Bank Sarasin-Alpen might owe me. But when it comes to Bank Sarasin-Alpen trying to recover its assets using that statutory regime, I can step outside it.
Yeah. Of course, if the position is, as you said, is that there are no possible directors' liability claims, being no possibility of them being pursued in Switzerland, the point ties in very clearly with that. So whether or not it's an absolute prohibition certainly impacts on foreign convenience.
It does. I mean, that point was a point I submitted in the context of whether Switzerland was even available.
Yeah,
and if your lordship doesn't think it's available. I mean, can I say on this point, I accept that these authorities are quite difficult, and they do require quite close analysis of the quite complex proceedings that were being articulated. And and so if your lordship was wondering about whether to decide this point, I would say you can get there on all of the other grounds, even if your lordship doesn't. And the reason I hedge my bets on that, this is something your lordship mentioned earlier about how this might play out. To put it on the table, we will consider whether or not we go down the anti-suit route with the Swiss proceedings, because we do think they are vexatious. We're not asking you to deal with that today, but that is something that is active in our minds, and obviously we will be influenced also by the outcome on today. And it may be that this point again arises in that context, because this might be one of the reasons why those Swiss proceedings are abusive. So I'll leave it in your lordship's hands. We say it is a good point, but it may be that because of the other factors, your lordship just feels there's no need to decide it now. Can I move on, my lord, unless you had any further questions on that?
No, I've just got one further question for you, which is how much longer you expect to be, because I'm thinking of taking a break at some convenient point. If you're going to be fairly short, we'll take the break between your speech and Miss Martin's speech and reply. But if you're going to be any significant time, then now might be an appropriate moment.
I'm quite happy to take a break now, and I could use that break just to look at my notes and see if I can cut anything further back. I don't anticipate being too much longer, but I appreciate that we need to give Miss Martin time to reply.
Well, but by too much longer, you are talking about something in excess of 20 minutes, are you?
No, I think subject to your lordship's view, I think I can get my notes down to less than 20 minutes. But if your lordship wants me to press on, so be it. Alternatively, I could use a break just to check that I can cut them down in that way.
All right. Well, I want a cup of coffee, so we'll take a break at this point. In English time, it's 11:22 or thereabouts. Let's say 11:35, 13 minutes from now or thereabouts, please.
Perfect. Thank you.
All right. Miss Martin, are you there?
I've just joined again. Thank you.
Okay, thank you very much. All right, whenever you're ready, Mr. Shivji.
I'm grateful, my lord. I have managed to cut my notes down, so I can hopefully wrap it up quite swiftly. We're on my third ground. We're on the defendant's third ground. We're now moving to their fourth ground, which is the practical considerations in relation to evidence. We deal with this quite fully in our skeleton argument in paragraph 65 to 72, which is page 3062 of the bundle. And there are four areas that we identify. That's the location of the parties and the likely witnesses, the language of the proceedings, and then thirdly, the documentary evidence stroke the Swiss blocking statutes. Now we say for each of these, the balance is very heavily tilted towards the DIFC and not Switzerland. I don't feel it's necessary to recite what I've said in writing, but we do rely on those points. I just wanted to pick up this point about these Swiss statutes. We don't accept that they are any material barrier to the progress of litigation involving the fourth defendant in the DIFC. The fourth defendant has been party to proceedings in the DIFC on previous occasions. There is nothing to suggest that those statutes were any meaningful barrier to the progress of the case. My learned friend gave an example of the authorization for Swiss witnesses to give evidence in this court, and she explained in her own submissions how quickly that was done. The application was made to the Swiss authorities. Swiss authorities came straight back with the authorization. So these are not genuine obstacles which would very heavily tilt the basis of the appropriate forum in favour of Switzerland. They're just the sorts of mechanics that come up from time to time. And in particular, the fourth defendant, as a Swiss bank, will be very familiar with these issues and the route through with them. So that, my lord, was all I had to say about the practical considerations beyond the point that I rely on in our skeleton. The next point was the defendant's suggestion that this case is really about the fourth defendant's role as a shareholder. I don't need to spend much time on that. We say that properly analysed, this is plainly not a shareholder's dispute. It's a claim about misconduct of the directors, and the fact that the fourth defendant was a shareholder of BSA isn't the key fact. It's its involvement in the appropriation of its business that is the key fact. This point doesn't in any event get my learned friend anywhere, because if she was right and if the applicable law was English law rather than DIFC law, the DIFC courts would still be extremely well placed to deal with those issues and far better placed to resolve them than the Swiss courts. And we've explained in our skeleton argument the undesirability of having a foreign court deal with issues of genuinely foreign law. So it is far less satisfactory for the legal issues to be put before the Swiss courts. And in any event, on the expert evidence, it appears that if it did go before the Swiss courts, they'd be applying Swiss law, not DIFC or English law. And so then that brings me to the final point, the existence of the foreign proceedings, the conciliation request. I've already explained to you right at the outset why we think that those proceedings are a device to derail these proceedings rather than a genuine attempt to find the appropriate forum to litigate this dispute. As your lordship has already noted, the existence of those proceedings is simply a factor for the court to take into account as part of the FNC exercise. There is authority for that proposition. That's the IGPL case. I don't need to turn it up, but that's paragraph 170 in the authorities bundle at tab 45, page 3809. And we say that is the well accepted law in the DIFC. Now, Dicey explains that the existence of the foreign proceedings may not be a factor of any relevance at all, depending on the facts. And maybe we'll just have a quick look at that. This is Dicey, chapter 12, page paragraph 12051. That's tab 34 of the bundle, and that is page 3485. And if your lordship could read, in fact, the whole of 1251, that would be helpful. It starts with just explaining what we've already discussed, which is that it's just a factor for FNC, and then it goes on to explain the assessment of those foreign proceedings.
Yes.
And I'll just pick up the bit at the end of the page 34 3485, the foreign proceedings may be of no relevance at all. For example, if one party has commenced them for the purposes of demonstrating the existence of a competing jurisdiction, or if the proceedings have not passed beyond the stage of the initiating process. And we say that we tick both those boxes here. So we say that the existence of those proceedings is at most a minor factor for your lordship, and this certainly doesn't tip the weight in favour of Switzerland. Now, just moving on from that point, my learned friend made some points about the time and expense of proceedings in Switzerland versus the DIFC. We support your lordship's assessment that this isn't some procedural comparative exercise regarding the benefits of each court. But in any event, there does seem to be, in my learned friend's case, some veiled criticism of the DIFC courts and the speed in which it dealt with the Carafi litigation. And we're surprised to see the fourth defendant raising that point. Your lordship may not know, that was the case in which the case went to the Court of Appeal on 4 separate occasions. And when it went to the Court of Appeal on liability, the Court of Appeal quite rightly complained about the fact that the defendants, which at that point was Bank Sarasin-Alpen and the fourth defendant, that they had sought to appeal nearly every paragraph of the judge's very lengthy judgment on jurisdiction, sorry, on liability. So the reason, one of the reasons why the proceedings took so long was the fourth defendant's own behaviour. So it is a bit surprising that they rely on that case as an instance of the apparent inefficiency of the DIFC courts. But in any event, we say that sort of exercise just doesn't arise, and on a principled basis, there is no need to get to that level of granularity. That then brings us to the second stage of Spiliada. I don't spend very long on this. I mean, we say that the knockout blow on their jurisdiction challenge is the first stage of Spiliada, not the second. But we do rely on 3 points as to why a stay would not be in the interest of justice, convenience and fairness. We say, firstly, and most importantly, the DIFC court is the only available forum for all claims. Secondly, that we would be seriously compromised if we had to sue in Switzerland because there are no equivalents to some of the claims that we wish to pursue. And then thirdly, we point to the fact that we have funding here and anticipate difficulty arranging funding straight cover in Switzerland. I've set out all those points on my written argument. I don't for a moment suggest that this is the linchpin to answering the case. We say that it's all answered by the first stage of Spiliada.
Well, it's pretty clear that if the Carafi family wanted to fund it, they could fund it, wherever it was.
I can't say anything further on that. It's a matter for them, my lord.
Right.
So, my lord, that I think that brings to a conclusion my submissions on forum. I'm happy to assist your lordship on anything else. There is this hangover point about relief from sanction. I mean, I really don't have much to say on it at all, but it may be that you want to hear from us on that.
I don't think so, really. I mean, the point can be summarised in this way, isn't it? The 3 hours out of time, no real excuse for being 3 hours of time, but it is only 3 hours, and then a delay in bringing the application for relief. Well, the question is, what does justice require at the end of the day? And that, as you rightly conceded earlier, depends really on the substantive point. So my inclination is to think it simply turns on whether or not I'm with Miss Martin on her main submissions. If I'm not, then there would be no point in giving relief from sanctions in any event. So it's going to go with the main argument, it seems to me. Subject to anything Miss Martin wants to say, of course, but that's how I see it for the moment. All right, so nothing else from you, Mr. Shivji, for the moment.
No, I just on that relief from sanction, just on their reason, that the reason put forward in their skeleton argument is there's some sort of suggestion of a misunderstanding on their part, but that alleged misunderstanding doesn't find a home in any of their evidence. And if one took the trouble to look at the chronology, it's quite clear what happened, which is that they applied for their stay. On both sides, we had hoped that the court would give judgment by the 20th of June, and we'd asked the court to do that. The court, perfectly understandably, didn't want to commit to doing that and removed that provision from the consent order. The fifth defendant then knew and wrote to us referring to the 20th of June being the deadline for the forum, for the jurisdiction application. And then they didn't hit it, and they didn't come back to us to ask for an extension until after the deadline had expired. So as you say, no particularly good reason. It's not a big point, but we don't technically. Denton requires some sort of reason to be offered, and we say that they actually properly analysed on the evidence. They've offered no reason at all. But I don't want to spend any more time on that. I'm grateful, my lord. Those are my submissions. I'm so sorry. Ah, yes, my learned junior, who's been looking. Okay.
Is he going to appear on camera? Is he going to appear on camera?
He's not going to appear on camera. He's helpfully just he looked at the point about the location where directors' meetings
yes.
take place. The articles which are not in the bundle say that a directors' meeting which involves a conference between directors, some or all of whom are in different places. The meeting is deemed to take place at the place where the largest group of participating directors is assembled, or if no group is readily identifiable, at the place from where the chairman of the meeting participates. So it's not even actually that straightforward, but there isn't. It doesn't really take my earlier submission any further. I still say there's nothing to show that this company was administered from Geneva, and that is the only point that your lordship needs to be concerned about. But I'm grateful for Mr. Sampson for looking at that.
There's nothing in the Companies Act about it, in fact.
No, I'm told.
It's subject to yes.
So it's subject to the articles.
Yes, I see. Yes, all right. Thank you very much. Ms. Martin.
Thank you, Your Honor. I thought first we could turn to the question that you posed at the beginning about whether or not the burden of proof under Spiliata was altered in this context. And I was helpfully reminded by my colleague that this court has undertaken that consideration of that question earlier in the KBC case. And the KBC case is in the bundle. And I believe at page 3843. And the portion that I would draw the court's attention to is paragraph 6, which is on 3846. No, sorry. My apologies, I wrote down the wrong page number. $38.43. 38.34. So starting with paragraph 6 through paragraph 8. So as we understand the argument that was put forward by claimants there, it's that the burden of proof should be higher on the defendants in the DIFC than it is in England and Wales, because they have to overcome statutory rather than common law jurisdiction. Now, I've not heard claimants' counsel put forward any such argument here, and I don't understand that to be their case. My understanding is that they have said that the Spiliota test is fine, and that's what they said in their skeleton argument.
Yes, but I decided it wasn't necessary to decide the point.
Correct. But I do note that
which is usually the case on burden of proof arguments in any event. The court's very reluctant to decide anything on burden of proof unless it absolutely has to.
well
Yeah.
noted.
Yeah.
Now we argue at paragraph 76 of our skeleton. Get you the page number here in a minute. Oh, 3027.
Yeah, I've got it. Yeah.
The basis of the Corinth case, which I believe that claimants also cite. So if we then turn to Corinth, which is page 3361.
Well, there's no doubt about discretion, is there? But, you know, the discretion has to be exercised on several principles, including form non-convenience principles. So what do you need to show me anything more than what appears in paragraph 76?
We would just note the sentence that says the principles of private international law limit the powers and discretion of the DIFC courts so as to prevent the exercise of exorbitant jurisdiction. And the DIFC courts possess the discretion to decline jurisdiction on grounds of form non-convenience.
Yes. And of course, it all depends what you mean by exorbitant, but yes, there it is. Yep, absolutely.
Yes, of course. We would suggest that jurisdiction over the fourth defendant is exorbitant here.
Yeah.
Now, turning to the sort of veiled criticism of the form in which the claim for negative declaratory relief came, claimant's counsel states that it is evidence that it is some sort of device. And what this suggests to me is that claimant's counsel simply hasn't familiarized themselves with Swiss procedure. This is simply how these cases are submitted in Switzerland. There's no inference to be drawn about the unseriousness of the pleading on the basis of the cursory nature of it. We complied with the relevant Swiss pleading requirements, or I'm sorry, my clients have otherwise through other counsel, and have done all they can, the defendants have done all they can do to diligently pursue their rights in Switzerland. There's nothing more they can do. The service is in the hands of the authorities here. There was a question raised as to whether or not the fourth and fifth defendant intend to participate in these proceedings should the court exercise jurisdiction over it. And I will say that it is a matter on which I don't have instructions, but I think it was suggested that we said that the fourth and fifth defendant.
No. Not that you said it, but that was the inference I was drawing from what had and hadn't been said.
Okay.
Obviously, you've reserved rights, which is, you've reserved your position as to whether you're going to or not, and I understand that. But it seemed to me that I had to bear in mind the possibility that whichever way these decisions go, the party who objects to the jurisdiction of each of the two courts might decide not to participate. So I've got to have that in mind, as well as the other possibility that there'll be full participation. So I don't think you need to answer the point. I'm not making any assumption in that respect.
Very well. Now, as to the point about the scope of the prohibition on creditors of the estate going elsewhere, could I draw the court's attention back to the Erste case?
Sorry, to which one?
Erste, it's the case that we spent a lot of time on claimant submissions.
Page?
3563 is the first page.
Here.
And it's I think the most relevant bits start on paragraph 51. which is page 3581. Now, the claimant has seized on this soundbite of requiring the creditor to have all questions of whatever kind as against the debtor resolved within the the insolvency administration of the court. But I would say two things in that regard. I think that the court should give some weight to this language as against the debtor. We think it's suggestive that the court here only has sort of mandatory liability over liability or mandatory jurisdiction over liabilities and not other types of claims.
Well, let me just ask you this. I mean, it's self-evident that if the liquidator had some counterclaim that he wished to offset, then one would expect that to be dealt with in the same regime, wouldn't you?
Well, they may wish to, but there's nothing in the DIFC insolvency law stopping them from going to other courts. There's nothing compelling a liquidator to bring claims in the DIFC.
No.
So this permissiveness should signal to the court that the drafters of the law consider there to be situations in which it might be appropriate to go to courts of other jurisdictions.
Well, just remind me. If you're going to bring, I'm more familiar with English insolvency law than I am with DIFC insolvency law. You know, there've been the 2009 Act has been replaced by the 2019 Act in the DIFC. But if you were going to bring a claim against the liquidator, or if the liquidator himself was bringing a claim, what sort of court permissions are required?
In terms of to bring a substantive claim against the liquidator based on the performance of his duties?
No. You're bringing a claim against the company in liquidation.
The company in liquidation.
Obviously, the liquidator has to act for the company, and now you need the permission of the court to do that, don't you?
Well, the only authorities I am presently aware of, Your Honor, and I'd be happy to go away and research this, are these authorities saying that anything having to do with attempting to exact a proof of debt against the insolvent company must be done in the company where the insolvency is being administered. That point is patently clear.
I don't think that can be quite right. I mean, I'd be very surprised. Certainly under English law, you can't bring a claim against a company in liquidation without court permission in the ordinary way. And if the liquidator wants to bring a claim, what I can't quite remember is whether he has to seek permission of some kind in England or the DIFC. Maybe Mr. Sampson can be looking at that to help me on that point. In case I may have it completely wrong, but
your lordship's right. Maybe I can just help just to curtail this. So under DIFC law, there is a moratorium once a company enters a compulsory process, and that's Article 88.2. That's not in your bundle, I'm afraid. And so permission is required if a party wants to lift that. There's quite a lot of authority on that, and I'm not going to try and summarise it now. There is, and then separately, your lordship asked a question about whether the liquidator needs permission. Yes. My recollection is the liquidator doesn't in the DIFC because that is part of his statutory powers on appointment. In England, it used to be the case that the liquidator did, but the position then I think changed with the arrival of the Enterprise Act. But I'm only saying that from long history, and I would need to go back and check what the position is, but that doesn't really matter for our purposes.
No, I'm just interested. When was the Enterprise Act passed?
I think it's 2000. I'm now freestyling. It's 2000. You're testing me my historical insolvency knowledge, which is hopefully reliable. I think 2002 was the Enterprise Act.
Wow.
So. But we'll check.
Yes,
I'm
okay.
a bit nervous saying that off the hoof, but that is my recollection that the position has changed. Or I maybe thinking of administrators now. I'll need to check.
Well, actually, it may only be a passing interest and is not going to be determinative in this case, obviously. But I would quite like to know the position. My own private purposes, if nothing else, because I ought to know the position. But I think, Ms. Martin, you must take it that if you were to bring a claim in the DIFC against the liquidator, where you were seeking money out of the liquidator or out of the company liquidation, then you'd need the permission of the court. Now, of course, what you're saying is a negative declaration in Switzerland, and different provisions will apply in Switzerland in any event. But if you were to bring them in the DIFC seeking a negative declaration, I rather suspect you might have to seek permission, in fact, from the court. The court always looks at this, and at the end of the day, there are all sorts of principles that apply in the court deciding whether or not to give permission, about which there's plenty of English case law. But one assumes there would be the question, is the game worth the candle? In other words, are there going to be any assets there that make it worthwhile? And indeed, the reason why there used to be a requirement for the liquidator to gain permission was it going to be worth his while to pursue a claim, given the overall state of the assets as against liabilities of the company. Not directly relevant for current purposes, I think. And so far as this point is concerned, the one you're addressing me on paragraph 51, it only bears on that indirectly, and this point itself is unlikely to be decisive overall. But your case, just to make sure I've understood it, your case is that all that this is saying is that in relation to the particular claim that the creditor wishes to pursue, if he's proved in the liquidation, he can't go off and get that sorted out elsewhere. And that's not the case here, you say?
That's correct. And if I could just direct the court's attention to paragraph 59, which I think after all of the analysis that we've already been through, there was just a tightly summarized holding in my view. It's sort of the middle of the paragraph.
Well, there's no question on the facts. They decide that it's much the same case that's being put forward. Yeah,
correct.
So the question is whether paragraph 51 in fact goes any further than that on a point that doesn't appear on its face to have been fully argued. I mean, Mrs. Justice Gloucester knew plenty about insolvency. Her whole life spent dealing with insolvency matters. Well, I see. I did something in this case in paragraph 58. Oh, I just granted leave to serve out. Yeah. Oh, well, there we are.
Well,
okay, I've got your submissions, I think. Thank you very much.
Thank you. I know that Claimants Counsel also made a point that we didn't reference our own skeleton very much. We know that the court has done its pre-reading. It wasn't our intention to rehash our skeleton. We do still intend to rely on it.
Sure.
We just wanted to be able to take on the claimant's pleadings efficiently. There was a point raised about whether or not the Geneva courts needed to specifically have jurisdiction within Geneva if, for instance, acts were taken elsewhere within Switzerland. And at page 1632, there is a Swiss civil procedure provision, number 8A, paragraph 2. And what it says is if there was in jurisdiction in the Zurich court, the Geneva court could also exercise jurisdiction based on that.
Is that a matter covered by Mr. Bresson?
I don't believe that he specifically covered it. We're just relying on the statutory provision here.
Let me look at it.
The claimants did not raise the point previously, I'm told.
My understanding, and I don't think either the Swiss lawyers have descended into detail on this, is there's both federal Swiss law and cantonal law. Am I right in that respect?
Correct.
Yeah. So 8A2. Sorry, I'm not understanding what you're saying about 8A2.
It's simply a matter that there was a point raised during oral argument that it might be that the Geneva courts didn't specifically, as a matter of cantonal law, I suppose, have jurisdiction if events took place elsewhere in Switzerland. And the point is that this provision would allow them to, if jurisdiction did lie elsewhere within Switzerland. And this is both regards jurisdiction and substance. And here, this is a case in which only Swiss federal law applies, I am told.
One would expect it to be federal law, certainly, but the problem you have on this respect is simply what Mr. Besson says.
May I turn to the director's liability claims on if the court's foreshadowing that that's where it's going?
That was the point I had in mind, that what he says there about it being necessary to show that Geneva is the place from which the business at BSA is administered. That's what I had in mind. The reference to which I don't have to hand, but have made a note of.
Addressing that, those claims really concern the actions of the individuals. And Jones Day was only retained by those individuals on the 5th of September. We really have not had access to information from them for very long at all. And so if there's any complaint to be had about belatedly filed evidence or that the evidence isn't before the court, the evidence is evolving. And that's in part because we have now been instructed by the individual defendants, and also because these are very old documents, and it's not necessarily easy to get access to all of the documents that we need access to in order to prove these points, but we are working diligently to do so.
Well, I have to tell you, Miss Martin, I have real difficulty with that as a proposition. I mean, on the face of it, you know, these matters have been outstanding now for a long time. There have been all these discussions without prejudice during a standstill agreement. And on the face of it, it would be very hard for me to think that the 4th and 5th defendants didn't have access to the directors to get whatever information they required when they were all essentially on the same side of the fence in these proceedings. Certainly, at an earlier stage, they appear to have lawyers who are acting for them all. Now, I know for the purposes of service and so on, the positions have been reserved, and lawyers have said, well, we're only specifically instructed after service has taken place, which is a good way of delaying service. But the idea that you couldn't have brought forward whatever you wanted to from the 1st, 2nd and 3rd defendants for the purpose of the 4th and 5th defendants' claim today is one that strikes me as really very difficult to swallow. You need to know that. I obviously proceed today on the basis of evidence before me, but it might be a factor that comes into play when I have to deal with the 1st, 2nd and 3rd defendants' applications, if they're made.
I understand that it doesn't sit well with the court, Your Honor, and that point is taken. I'm just here to proffer to you as a factual matter that those are the facts. As
to when you were instructed. Well, I understand that when you were instructed, and that's you're entitled to say that. That's fine. Thank you.
As to whether,
go on.
My apologies.
No, you go on.
And now, as to the administration of BSA, I do think it is important to really take a step back and understand the business. This is a joint venture that had very few delegates, essentially, from either of the joint venture partners seconded in to do some administrative duties. And then it had the relationship managers who managed the relationships with the clients. And then the admin was actually done on a shared services basis by the other joint venture partner, the Alpen company, with all of this sort of infrastructure for the banking products that these clients desired sitting on the fourth defendant's books in Switzerland. And so I, with all due respect to Mr. Shivji, I consider it a bit naive to simply assume that because it's a DIFC company, the administration of the company took place in the DIFC. A lot of these decisions were made at the shareholder level because they absolutely had to be, because they were so intertwined with the bank and its activities. Now, I hesitate to go too far down this route. To me, these are merits arguments, but I do think it's really important for the court to truly understand the business when it's making these decisions and to really give thoughtful consideration to what administration of this business means.
Well, the administration of BSA's business is in the marketing, isn't it?
I'm sorry, the marketing?
Yeah.
I know that that was a prior finding of this court. The fourth defendant has a significant quarrel with how that is characterized, that they didn't view BSA as simply a marketing organization. They had a license from the DFSA that allowed them to arrange credit. And if you ask individuals at the fourth defendant how they would describe the business of BSA, they would say it was the business of arranging credit. Now, that credit, again, was arranged and then put to the fourth defendant for the fourth defendant to make a decision on whether or not they would actually give that credit to that client. But that's a licensed activity. That's not mere marketing in the view, again, of the fourth defendant.
Well, I understand that doesn't really affect the point that I'm making or has been made against you by the claimants as to where the business was being carried out. Of course, the fourth defendant had to decide what it was going to do. One understands that, but that's a different business from that which BSA and indeed the fifth defendant is now involved in. Otherwise, there'd be no purpose served in having the fourth or fifth defendant there at all. As you say, you need a DIFC license and you need your relationship managers and all the rest of it. Anyway, there it is. I think I have your point.
I guess my last point on that would be perhaps we are not quite aligned on what administration of the business means in this context. I suppose when I hear the phrase, I think of something along the lines of managerial activities. And those types of supervisory decisions, again, many of them had to be taken at the shareholder level, just given the way that authority was delegated within the group companies that BSA sat within. Now, the discussions with clients, they happen, frankly, all over the region. They didn't even necessarily happen at the offices, although, of course, some of them did. But some of them happened offshore and elsewhere.
That'll depend where the clients are, won't it?
Exactly.
Who I assume are mostly Middle Eastern, but I don't think I've got any evidence on that.
And my colleague points out to me that just one last point on this, that there were certain matters that were reserved within the shareholders agreement, and of course those had to be taken at the shareholder level.
Yeah, understood.
As for the prior case, the Al-Kharafi case, we bring the 6 years to the court's attention simply as a matter of fact. It's not meant as disrespect to this court at all. It was just to juxtapose it with the 3 years stated in the Lalive report, that if you're going to compare those two timeframes, surely on their face, one is longer than the other.
Yeah, well, I think, as you say, comparing length of procedure is not going to help very much. And certainly this court with there's going to be no delay if I'm in charge of this case.
We've noted, Your Honor. As to the Al-Kharafi case and whether or not it is an appropriate analog to what might happen in discovery here, we would submit that it's not, because that was against a single client who had necessarily consented to the disclosure of their financial and banking information by virtue of bringing proceedings here. It's a very different scenario from the one we're in here, where there's no particular client whose data is an issue. And I would also suggest that Mr. Shivji making a comparison between the permissions sought by the Swiss potential witnesses here today and disclosure that may be required through mutual legal assistance. That is a very apples to oranges comparison. The Swiss authorities put in very specific procedures for the type of permission that was required here today. They have not lifted mutual legal assistance for providing certain types of disclosure out of country. Those would be my points on rebuttal, Your Honor.
Okay. Right. So is that it?
But there was
nothing else you want to say?
Well, there was some question at the end of the claimant skeleton raised about whether or not our seeking a forum nonconvenience order was Henderson abuse. I frankly find the argument a bit confusing. I think what they're saying is that because the fifth defendant has previously applied for a stay, that somehow alchemized.
I don't think you need to deal with that. I mean, that was based on whether or not you were the second part of your claim. Your application was based simply on case management grounds, but you've made it plain in your skeleton that actually it's simply a further way of looking at your case on forum nonconvenience and les alibi pendens. You either seek dismissal on the one hand or stay on the other, or a limited stay until the Swiss court has decided what it's going to do.
That's correct, Your Honor.
Yeah, so you don't need to answer that point, I think.
Thank you.
All right. Is there anything you want to say in relation to the new point that's been brought up about Article 8A of the Swiss Procedural Code, which I must say I'm having difficulty in understanding?
I had the same point that your lordship did, that the experts have looked at this and they haven't identified that provision as relevant to this question. And our expert was categorical. Mr. Besant then came out with a qualification, and he did not mention any further qualification on this point. So we just say it can't be for counsel to be making submissions on Swiss law that their own experts haven't identified. My lord, sorry, I'm so sorry.
It appears on its face to be dealing with two or more claims having a connection between them, and working on the assumption they can be brought into Switzerland. It's all about co-defendants and plurality of actions. It doesn't seem to me on the face of it to be directed to the point at issue, but I may not be understanding it.
Well, I agree with that assessment, but I'm reluctant to say anything about it because this is the first that my attention's been drawn to it. I don't know what it means, or whether it even applies. My lord, I said that we would just go and check that position about liquidator's sanction. So perhaps I could just give you the answer on that.
Yeah.
So the sorry, let's get my note back up. So I was right, luckily, in what I said earlier, that the permission was required historically under English law, and the position changed with the Small Business Enterprise and Employment Act, not the Enterprise Act. So that was actually 2015, not 2002. So it has changed a bit more recently, although it feels like a long time ago. The position under DIFSO law is that permission is not required, and that is under the Insolvency Law 2019, Article 53(1).
That's very helpful. It's also comforting that I wasn't as out of date as I thought I was in English law, having retired from the English bench in 2016.
Very good, my lord. Can I just deal with one point that my learned friend raised about? I know that this is potentially a rabbit hole. I don't want to go into it, but this idea that they don't have access to the individuals. I just wanted to mention one point, which I think is an easy one to make. Mr. Astruct, who is the second defendant, is the fourth defendant's general counsel. He is their current general counsel. He is named in the conciliation request as their general counsel. And when they went to get so the conciliation request says Mr. Stefan Emil Astruct is a member of the group executive board and general counsel of Bank J. Sarasin if your lordship turns that up at page 1235. That is, as I understand it, a statement of the current position when the conciliation request was issued and remains the case. Mr. Astruct is their general counsel. And then if you go a line up, it says Mr. Elie Vivien Sassoon is a member of the General Executive Board and heads the private banking division of the fourth defendant. And he is also, we've pleaded this elsewhere, currently a director of the fifth defendant.
It's Mr. Carton who no longer has a direct connection with the other defendants.
That's correct.
That
He
is
has no affiliation. That's correct.
Yeah.
Nor has he for several years.
Yeah. So, but that point obviously is not the case for the first and for Mr. Sassoon and Mr. Astruct. And just to sort of emphasise the practical access point, if your lordship then goes in the bundle to J221253, this is the document which records the collection. Records the collection of the DIFC proceedings that we served through diplomatic means in Switzerland, and this is a receipt of collecting the proceedings. And if you look at the bottom of 1253, the person who signed for their collection, and as we understand it, he was signing on behalf of the fourth defendant who's listed in the middle box, was Mr. Astruct, and that was on the 9th of August 2023. So, I mean, my learned friend, I think, was talking about Jones Day's access to those individuals. But yes, if there cannot be a submission that the fourth and fifth defendant don't have access to these individuals, because plainly they do.
Understood. I don't want to have too much toing and froing, but is there anything you need to add, Miss Martin, to that?
May I ask the court's indulgence for one moment while I confer with my.
Yeah, of course. Yeah.
Thank you. Thank you for the indulgence. The point about the new Swiss law provision was really just that it was responsive to something that Claimants Counsel brought up today, which is that certain actions took place in Zurich. And apparently the way that this provision works is that if there were tort claims that were viable in Geneva, but liability claims that were viable in Zurich, this provision says that those claims can all take place in one court, one or the other.
Yeah. All right. Understood. Thank you very much. All right, so that's it. Nobody needs to say anything further. What I propose to do is to give you my decision now, and then give you the reasons later in writing, which need not, I think, in fact, be particularly long. But I can see no basis upon which the application for dismissal of the claims could succeed, and likewise I refuse the application for a stay of the proceedings, whether temporarily until the Swiss court decides whether it has jurisdiction, or more generally on the grounds of lis alibi or forum conveniens, or indeed any other grounds that have been advanced. So far as the issue of relief from sanctions is concerned, it appears to me that really goes along with the application for dismissal or a stay, no purpose would be served, in fact, by granting such relief. I've already indicated that I don't see there being good reason for either missing the time at the deadline in the first place, and no reason for the delay in applying for relief from sanctions. Had, however, justice required me to grant such relief, because it would have deprived the defendants of what would otherwise have been a solid basis for their application for a stay on the grounds of forum non-convenience or stroke lis alibi pendens, then I would have been inclined to grant such relief. But as it doesn't, I don't. I've already granted the extension of time for the claimants for service on the fourth defendant. So I think that resolves all the matters that I need to resolve, subject to the parties receiving my reasons, which I would hope to get out in the course of the next day or two, but which you probably won't get till next week sometime, once it's been through the system of the DIFC courts and topped and tailed in a manner that fits the documentary requirements for granting of orders. Is there anything else you want me to deal with at this stage? Obviously, the costs issue arises. On the face of it, one would think, unless there are any peculiarities, that costs would follow the event. But do the parties want to make any submissions about that now?
Yes, my lord, if I may. We would ask that we have our costs and we have them on the indemnity basis. And I say that for two reasons. One, because the substantive arguments run by the defendants in some cases weren't properly arguable points, and the Singapore service is a good example of that, as indeed is the idea that the DIFC is somehow obliged to apply the lis alibi pendens rules from the Brussels Convention, but also more generally on the basis of what your lordship's already seen in terms of the conduct of the defendant and, as we say, these sort of repeated efforts to delay the progress of these proceedings. I also say that one of the reasons we ask for costs is because this is an insolvent estate where we are litigating, and if we have been successful, there's no reason why the estate should be deprived of the money that it's spent in pursuing these applications. We know that the defendants have already said that they are gearing up for security for costs, and we'll have to deal with that if it comes. But that we ought not to be deprived of money that we have fairly spent on an argument that shouldn't have been brought and which we have won. Now, we have also filed a schedule of costs. I'm in your lordship's hands as to how you want to deal with that. There are two options. One is for the court to summarily assess costs. Sorry.
Let's deal with principle first, shall we? And then decide whether or not we're going to go further at this stage. Ms. Martin, what do you say about the principle, both of the claimant getting their costs and secondly getting their costs on an indemnity basis?
Your Honor, I would posit that costs should be in the case, but to the extent the court feels otherwise here, indemnity costs are not appropriate here. We had a good debate about many of the points that were raised in the fourth and fifth defendants' pleadings here today, even on points in which the court didn't take quite as well. The court did acknowledge that if justice required, that it would have ruled in the defendant's favor. And for this reason, we would ask the court, if it is inclined to assess costs on the event, to do it on a standard basis.
Right. In my judgment, it's an appropriate case for costs, but not on the indemnity basis. Some of the points were arguable, and I think costs on the standard basis is appropriate. The only real difference arises in relation to the questions of proportionality and who has to show whether the costs are reasonable. I personally adopt a much more relaxed and realistic approach to costs incurred in the DIFC than is usually the position in, say, England, where on the standard basis one might expect 66% of costs or thereabouts. The approach here is much more akin to that in arbitration, where a larger figure is much more normal. And the only real question is what is reasonable in the circumstances. Now, I haven't looked at the figures at all. I think before we decide whether we're going to do any summary assessment or make an order for an interim payment, I need to see what those figures are, and we'll have any debate that needs to be had at this point. Is there a schedule in the bundle, Mr. Shivji, or is it somewhere separate?
We filed them in accordance with the rules. I don't think that they've been inserted into the bundle, but I hope that they might be on your Lordship's case system.
Let me just see. I may well have received an email. Just bear with me for a moment. I don't think I've got a schedule of costs sent to me by email. So, but you think it'll be in the case management system somewhere, do you?
Yeah, well, we filed them. I'm just wondering. I've just messaged my solicitors. I wonder if they can just.
Maybe here we are. It's under events in the case management system. Yes, statement of costs, 6 September. Seem to be 4 different entries. Let me just check and see what they are.
There are, and let me just explain what they relate to. So there should be one for the jurisdiction challenges. There should be one for the adjournment application, which your Lordship dealt with previously on paper, and there will be one for the relief from sanction application, and then one for the extension of time. Yeah. So I'm sorry that we'll break it up, but I think the view we took was that you had to have them separately because otherwise it would all be tied up and that would be a mess.
Well, the simplest if I try and deal with it all today.
It would say.
Do you have all these, Miss Martin?
We do have them, Your Honor. A couple things I would point out is I was wondering if we could get a further breakdown of counsel's fees, and I would also point that it appears that over half of the overall expenses is their expert report. Oh, no. Sorry, half is apparently counsel fees plus expert report, but that appears to be a very expensive expert report from our experience.
Yeah, I'm not with you because I haven't got as yet. I'm trying to work out which ones I should be opening here out of the 4 that are deal with these individually. I'll download them first. That's probably easiest. I'm sorry it's taken me some time to download. So the one I'm looking at first is well, I assume this is the main one, which has a figure of 950,000 odd dinar, dirhams. Yeah.
That's it. That's right.
So let's just look at it. So that's 950,000. So this is the large one that focus should probably be given
That's
to.
correct. Yes, my lord.
Right. Ms. Martin, you want to address me on the particular aspects that you're drawing attention to are council's fees and expert fees, is that right?
That's correct, Your Honor. If we look at what is page 3, I believe, of the document, and
Yeah.
the sort of block entry for all of council's fees,
Yes.
but in particular, the very last line says la livre, which is 69,000 Swiss francs or 288,000 dirhams. It is more than a quarter of the costs.
Well, have you produced? Have you got a comparative schedule of costs for yourself?
Your Honor, we were in the unfortunate situation of our billing software being down yesterday to put out the month-end bills, but that is something that we can turn our attention to after the hearing.
Well, the point at issue is sometimes it helps to see what the other side's costs are, but not always, because comparisons are not necessarily the same. But my experience of Swiss lawyers is that they are incredibly expensive. But let me just have a look and work out what that looks like.
I'm told that we don't actually have the invoice from our Swiss expert yet because there was a question on VAT. So my apologies.
So that wouldn't have helped anyway.
Our back of the napkin math says it's 30%.
What's 288,000 dirhams in dollars terms divided by 3.67? Someone do the maths. $80,000,
79,000. Correct.
Yes, $79,000. Yes. Okay, and you don't like council's fees either. I'm taking. Go on.
It's a number of council. We would just ask for a breakdown and perhaps an explanation of why there are so many.
Well, it's Mr. Shifji, Mr. Sampson, and Mr. Sharafi. Is that right?
Yes, that's correct, my lord. And Mr. Sampson is here with me. Mr. Sharafi is a junior. I think the view, quite rightly, was taken that the work they do is far cheaper than the work that I do. So and as your lordship can see, I think from the enormous authorities bundle, and in fact the bundle runs to some 5,000 pages for this hearing. There has been a lot in issue and a lot of work. So we would say that our fees and all of that are reasonable. And Mr. Sharafi is not attended today for reasons of cost. So we have been quite sensible on that front.
So you hopefully put the figures in pounds, which helps a bit. So it's 25,000 and 20,000 and 11,000 in terms of pounds, right?
That's right.
Your Honor, I would note that they have approximately 6 solicitors and 2 counsel in attendance here today, whereas we have 3 total lawyers.
So I say that again.
I would note that between HFW and claimants counsel, they have a total of 8 representatives attending this hearing here today, whereas, or perhaps it's 6 total. We're trying to take it from our view of the HFW conference room, but in any event, we have 3 total lawyers on behalf of the 4th and 5th defendant here today. Seems disproportionate to us.
Do you have any other points you want to take about the details of this?
I don't think so, Your Honor.
Right. Right. Well, I've examined this particular bill. There are no objections taken to the rates that are being charged. The specific objections are taken to the number of counsel involved when combined with the number of solicitors involved, and in particular those attending the hearing, and a further objection to the Swiss experts' fees. So far as the Swiss experts' fees are concerned, the experience of this court is that Swiss lawyers are invariably expensive, and there can be no doubt and no suggestion being made that these fees aren't payable. And I see no basis for concluding that they are unreasonable in the context of the practice of Swiss lawyers, particularly in the absence of any evidence as to the fees charged by the Swiss lawyer engaged on the part of the defendants. Counsel's fees do not appear to me to be in any sense unreasonable. And so the only question is whether there's some fat in this bill in terms of its overall figure and the number of people who are involved. I'm bound to say that I usually find that when I look at solicitors' bills, it's hard to understand quite why so many people are involved, but there are often good reasons for that, including delegation of tasks to the less expensive members of the firm, in the same way as as tasks are delegated to less expensive members of council where it's helpful to do so. Looking at it in the round, it seems to me that a figure of 80% of the total is appropriate, which, if my mathematics are correct, comes to a total of 760,000 AED. If I've got the maths wrong, someone will tell me, but that appears to me to be a reasonable figure in the circumstances.
Your Honor, thank you very much. I would just bring one more factual thing to your attention because it was just communicated to me on Mr. Mueller's fees, who
yes,
you may be familiar that he is one of the Lenzenstahlen lawyers who has been instructed. He has, of course, been assisting with the Swiss procedural aspects, and his fees are apparently half. And he's been assisting all along the way, not simply for 2 days for the purposes of producing one Swiss law report. So on a comparative basis, this still seems very expensive to us. And my apologies for the belated information on that point.
But my Lord, only point to make on that is, of course, he's not the only person who's dealt with the Swiss law for them. They've also had Mr. Besson. So you would, in order to work out the cost on their side, you'd have to have both, which we don't have.
Well, I appreciate that. I was just looking at the reports to see. I don't think that's going to change my view, I'm afraid, in the absence of a combined figure from Mr. Besson and the other Swiss lawyer. So no, the figure holds good, 760,000 on this bill of costs. All right, let's look at the others, which I assume will be for rather lesser sums.
Yes, my Lord, these are much smaller features. So there were 3 others. There was the adjournment application, and the figure there is the total. This was all done on the documents. The total was 25,687
AED.
AED, and this was your lordship. When your lordship dismissed the adjournment application, you ordered the 4th and 5th defendants pay costs on a standard basis. And you said to be subject to assessment by the registrar if not agreed, but not to be assessed or paid until after the determination of the jurisdiction challenges. So
right.
It's a matter for your lordship. We thought you might want to deal with that today, just because it saves us then having to go through the expense of assessment process with the registrar.
Well, I think it probably depends whether Miss Martin is happy that I should deal with it today rather than going off to the registrar.
Well, we've already engaged with discussions with claimant solicitors on this point. Oh, my apologies. I'm told I'm talking about another application. So
yes,
I'm happy for the court to deal with this here today. It's what, 24,000 dirhams.
25,000 dirhams. Yeah. Let me just find the bill. And have you got anything you want to? When we found the bill, can you address me on whether you want to say anything about its particular? It's probably that one.
Please, if the court could just indulge me a moment.
Yeah, it's all right. I'm trying to find it myself.
No specific objection, Your Honor.
All right. 20,000 AED. Next one. I've got one in front of me for 154,365. What's that one relate to?
That's the extension of time application, my lord. Now that is, there are 2 parts to that. One is as against D4, And separately, there's also the adjourned part against D1 to D3. And our estimate is about half of the cost. My solicitors tell me 50% of these costs they think are fairly attributable to the application against the fourth defendant.
Oh, I see. Yes, because it's an extension of time in respect of all.
Yes.
May we just
Different.
receive an explanation as to why it's a half and not a quarter?
Yes, but I was about to ask the same question. It seems to me I can see that there may be different criteria or different elements that might apply because the fourth defendant had already been served in Singapore, or arguably had been served in Singapore at that stage, and whether or not, therefore, there could be slightly distinct arguments, but I'm hard pressed to see that that would account for half of the bill.
Your Honor, I would just emphasize that they didn't make their application subject to a primary argument that service in Singapore was effective. They made it without that reservation.
Well, I don't agree with that, but let's not get into that. Just on the reason why the costs are we say about half is that the fourth defendant put in evidence in opposition to this application and put in its own skeleton argument, which ran to 12 pages with authorities. So we had to prepare for the known opposition on the basis of the points that they have taken and lost on. So that is why instructing solicitors think half is a fair estimate of the work involved.
Do you want to say anything more, Miss Martin, about that?
Nothing more, Your Honor.
Uh, 60,000. And that's working essentially on the basis that half is approximately right for the fourth defendant, and we need to bear that in mind, I suppose, when it comes to any argument as to the other three defendants should that arise.
Thank you. We'll keep a note of that, my lord. Thank you.
And the last bill.
The last one relates to relief from sanctions.
Yeah.
We do have objections on this one, Your Honor, when the court is ready to hear them.
Yes, thank you. No, wrong one. I don't seem able to find this one at the moment. Is anybody else looking at the event section of the case management bundle and can direct me to which particular statement of costs it is?
The figure, my lord, is I don't have access to that system. I'm so sorry, but my solicitors hopefully will send me a message telling me how to do it. But just in terms of the figure you're looking for, it's 40,895. That helps you if you're wondering whether you got to the right document.
Yeah. Okay, I've got it. Yes, Ms. Martin, what would you like to say about this one?
The claimants put in no evidence. They didn't put in a separate skeleton. They put in 2 paragraphs in their skeleton related to jurisdiction, and they cited no cases. So query, what were those 40,000 dirhams spent on? As between 4 solicitors and 3 counsel.
Well, you can see what they say they're spent on in terms of hours.
It doesn't appear to be drafting or researching.
Well, work done on documents, well, that's not very much. Attendances at hearing. Attendances on opponents, attendances on blank, that says, under the first heading in costs. What's that, Mr. Chibji? I assume it's client, is it?
I'm just going to take instructions on that. I assume it's client as well, but I'll take instructions. Yes, clients.
It's all bits and pieces, isn't it?
Yeah, I think it was an agenda item. We obviously had to spend some time preparing on it, and this is what we think is a fair estimate of the time we spent.
Yeah, well, I don't think I've got sufficient detail here to be able to see that that's all justified. I'm afraid I'm going to take a very broad brush approach to it and say you can have half of that, or 20,000 in fact. It's hard to see how all that time could have been spent, and hard to see how you would differentiate it from what else time and money was spent on. So 20,000 in respect to that one. Thank you very much. All right.
I think I had one last item just on the agenda for your lordship, which was the extension of time application in relation to the first to third defendants. I mean, we heard some submission from my learned friend during the course of today about what they are busily doing. We are concerned about delay, and so if they have an application that they're intending to make opposing extension of time, it seems to us they ought to do that very swiftly. And then, subject to your lordship's view, if your lordship was able to hear it, we think that would save hearing time, and we would be prepared to come back very shortly to do that. But we think it would be helpful for the court to put in place some directions for that to happen. Otherwise, if the usual RDC rules apply, there might be an argument about the nature of the application, and it could be some weeks before we're back before you.
Do you have clear instructions, Ms. Martin, as to what is going to happen next? Or is the position that you will wish to see, wish to consider the decision made and, if necessary, the reasons that I'm going to give before you decide what you want to do next? Or were you planning to file something in the immediate future regardless? You're on mute.
The intention was to file something, but in light of being potentially given the opportunity to take instructions, I would appreciate the opportunity to avail it. I think it is likely that the first through third defendants will file an application in very short order. They're not going to wait I believe it's 14 days that they have under the rules to do it.
Yes, I'm sorry, the application is going to be for what?
To contest the jurisdiction of the court.
Right, so it would be both extension of time and jurisdiction generally.
That's correct.
Okay, on the basis that there's some difference between those defendants and the fourth and fifth.
Correct.
Yes. Well, that's going to be quite ambitious, I'm bound to say, but you must take whatever course you think appropriate. How quickly can you do that? I mean, obviously you will want to have a further thought, but if you've already got it drafted, then how long will you need to actually make the application?
Well, in light of the court being poised to hand down a statement of reasons early next week, we would appreciate the opportunity to review that with our clients before filing, but we can do it perhaps if the court is able to get that to us by Tuesday. We could offer Friday if that's okay.
10 days from now, basically.
I believe it's 7th.
Oh, today, Thursday. Yes.
Yeah.
Okay, well, end of next week. Yeah, let's say Friday next week. Okay, and is that a matter that you will want dealt with at a hearing or on paper?
I think it's likely. My apologies. I think it's likely that the first through third defendants would like a hearing, but again, I would like to take instructions before committing to that.
Yes, I mean, I think whether you like it or not, you'll get me again, because that's simply a court efficiency to have the judge who's dealt with one matter to deal with related matters.
May I just raise one additional item, Your Honor?
Yes.
I, again, need to take instructions on this, but I do understand that under RDC 44.6, I need to preserve the fourth and fifth defendant's right to appeal today. I'm not seeking, well, I am seeking permission if that is what's required today, but at the very least seeking leave to obtain instructions before putting in any formal submissions on appeal.
Right. Well, I'm going to refuse you permission today, which means that if you want to pursue it, you'll have to go to the Court of Appeal on a renewed application for permission for the reasons which will appear in due course. I don't think there are realistic prospects of success on any appeal from the decision that I've given. And in those circumstances, you'll have to persuade the Court of Appeal that that's the case. All right. Do you think, Mr. Shivji, you could produce for the court the orders that I've made today, seek to agree those with Ms. Martin in terms of orders, and as and when the orders are made, my reasons will be attached, and make sure that the order covers everything I've actually made an order about today.
Yes, we're pleased to do that.
We'll put a liberty to apply at the end in case there's any delay in Miss Martin getting the reasons for whatever reason, what goes on in the court administration and the like. But otherwise, we will work on the basis that any application to be made contesting the court's jurisdiction and the extension of time by consent to be filed by Friday, the whatever date it is, be the 15th, will it? Yeah.
That's right. That's right.
I suppose close of business, which Jones Day will be well aware of the time that close of business is.
I might get a tattoo of 4 p.m. Yes.
on Friday the 15th. All right. Is there anything else for the moment?
No, that's fine, my lord. In terms of progressing that, I mean, I think we'll wait to see what their application contains, because we don't know yet how long it will take us to reply, and obviously that will depend on the substance. But I know that my client is very eager to get past these jurisdiction stages and get into the pleading stages. So is the best course that once we've seen their application for us to write to the registry asking about your availability and proposing some directions to get that application through to a hearing? Is that your lordship's preferred course?
Well, I think anything at this stage is undoubtedly premature as to how long anything will take and if there has to be a hearing, the duration of it. I'm just looking at my calendar the sort of expectation would be that if Miss Martin files evidence and so on by the 15th, then because some of this is going to be well traversed ground, the likelihood is you ought to be able to deal with it within a couple of weeks thereafter, one would have thought. And therefore one would be looking potentially at dates for a hearing sometime in October. Does that sound about right from both parties' perspective?
It does from mine. I mean, my learned friend hasn't mentioned that they're planning any Swiss law expert evidence as part of that application. I mean, if they did, that might change my assessment, but assuming that they don't, then I think we could turn around very quickly.
I think an October hearing sounds right, Your Honor.
Yeah, okay. Well, again, it's probably premature to even think about exactly when, but I do have some dates in October where it's possible.
Is it useful for your lordship to share that with us, or would your lordship rather not? It's entirely, I can understand if you wouldn't, but it strikes me that it might be useful for us to know that those are dates that we really ought to be working towards, because what I don't want to do is lose the opportunity of that window, and your lordship no doubt has other commitments, and then find we have to wait for the next window.
Well, realistically, as matters currently stand, and as you know, schedules change very speedily, but as matters currently stand, I could do October 4th. Oh no, that's a Saturday. I could do October 9 and 18th or 19th. That actually, those look to be, I think, 17th of October, or 17th, 18th, 19th, and that actually looks about the right sort of period, doesn't it?
It does.
I would have guessed. So at present, I suggest you sort of aim for those dates. And if there's any developments, you let the court know so that I can be told to either pencil it into my diary or not pencil it in, as the case may be. Does that help?
That helps a lot. I'm very grateful for your lordship, and I think we will. I mean, that seems like the right target to us. So, I mean, we'll be very happy to work on that basis.
All right. Thank you both very much. That's been very helpful. Grateful to both you and your teams for the helpful submissions and the work done. So thank you very much. If you would all sign out so that I can have a quick word with the court associate, that would be very helpful also.
Thank you, Justice Cooke.
I'm grateful.